Good morning, good morning, good morning. I can't believe it's December. It's Tuesday. It's December 3rd, and I had a different show planned for you this morning, but we had a verdict come in the YSL case, and I think we probably should just talk about that together. So if you have seen what happened, no spoilers. And if you haven't seen what happened, I think we should go over that first. And then we will talk all about what's going on in New Mexico, because that is, like, girl. I don't know if I have other words than, but girl, like, girl, what are you doing? Like, what are you doing? So Bite Me 95 said, "Oh my God, I had this open in the background while working and Emily scared the ever living crap out of me. I'm sorry for the morning jump scare. Maybe well, I didn't want to do an intro card to like ease everybody into the stream because then the replay crew, love you, replay crew, has to like go click, 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 click to get past it. But maybe we will for the live streams and then cut it after the stream is done and see if that works. So for all of the members that were in our recording yesterday for the podcast, it was late night. But I will let you know that we did have a copyright issue, but it only blocked the video in like 2 countries. So I think it's going to be okay for tomorrow's podcast. So we'll see. But I think we should go to, let's see. I'm going to put up a poll. I think we should just watch the YSL verdicts, right? So watch the YSL verdicts. The answer is going to be either yes, watch them. Yes, let's watch, or no, just cover it. Because either way, we're going to talk about it. But I figure watching it come in might be more interesting together. And then we'll get to Kari Morrissey. So that's kind of what my thought is. Blah, 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 blah. Sorry, I said that wrong. I apologize for, it's not really misenunciating your name because it has to be blah, blah, blah. Still stuck on social media is a criminal organization. Yeah, I'm still not done. Tree Sellin said, why not both? Well, we're going to talk about it. It's just whether or not we watch the video come in or I just tell you what happened. So we'll see. And Shalyn said, it always starts mid Emily talking. Yes, there is a little bit of a delay when it starts. If you replay crew, you will see me saying good morning. And that's what it is. So we should probably just do the things, right? I'm still stunned by what happened. Like, I still haven't processed yesterday, and I watched a few other attorneys cover it, and I'm still not processed. Like, I've never seen anything quite so wild. I couldn't even explain it well to Judge Abby. I was just like, you're never going to believe all this. And do you know what Judge Abby said to me? I hope Judge Abby doesn't get, I'm teasing. I was just hearkening back to yesterday. Do you know what she said to me? Ooh, I'm so curious. What did the judge say in sentencing? And I said, right? Yes, like Ariana Grande. I said, right? I want to know what the judge said too. And so then I had to tell her. He said, I sentence you to life. That was it. It was so, I was waiting. I was like, Judge, let's go. I sentence you to life. I was like, I was so sad. I wanted him to be like, ma'am, we hear you talking, but no. But he's not going to argue with her, right? He's not going to argue with her. I want him to argue. But he's not going to argue with her. let's roll the intro and we'll go from there. Don't worry, we're going to get to all the things today. We're just gonna add in a little bit more. So let's do that. Let's roll the intro and go from there. So let's get it going. Y'all, I think we're gonna go to live court. The poll says yes. The poll says yes. The chat's divided, but the poll says yes. So I think we might go to court. Let's roll the intro and see.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
All right, I'm going to pull up my notes real quick so we can go over where we're at in the YSL case. I covered it a bit when Young Thug took a plea deal. You remember us going through this. When Young Thug took a plea deal, his attorney was standing in court, like pulling his face. He was just like, so we're going to have to do a bit. I saw somebody ask, Jenny asked for the road so far. Yes, we're going to do the road so far. It's very needed. I didn't say road so far, but we're going to need to do the road so far. So let me grab my notes and let's do a little bit of a road so far. At some point, we're going to need like a road so far noise, but not yet. We're going to need like a thump thump. No, not like no, we're going to need something a little more supernaturally, but we'll figure it out. Let's road so far. This case was already the longest case in Georgia history because jury selection started, and I talked about this in Quick Bits this week as well, but jury selection started in January of 2023. January of 2023. Coming up on 2 years ago when jury selection started. Jury selection ran until November 2023. They started the case in November. Verdicts 24. 2 defendants remained in this trial that originally started with 7 defendants, and people pled out along the way. But when this 88-page RICO indictment came down, they charged a total of 26 defendants with more than 55 charges. Some of the defendants, all of the defendants had the RICO charges, and then other defendants had different charges. And so they had mixing and matching of the charges. But when Young Thug, who was kind of the lead named defendant, pled guilty, his lawyer was just like, do not do this. Do not do this. His lawyer's like, he wants to get out. I want him to ride it through to the end of trial. And I went through his plea deal and his extensive amount of time on probation. But he also took a bunch of felony charges, like a bunch of them, because he had to plead open to the court, or plead blind, as they call it in Georgia. He pled open to the court and is on like 40 years of probation. But he has room to like roll off of probation towards the end. But his lawyer was like, no, I want you to see this through. But that's not his lawyer's choice because his lawyer's not the one sitting in custody. And he pled what? A month ago. November 3rd? A month ago. He pled a month ago. And a bunch of other defendants pled out, and the jury came back with a verdict this morning. So we're going to go see what the verdict is for the remaining 2 defendants. Yak Gotti and Shannon Stillwell are the last 2 defendants. There have been so many defendants in this case, and so much has happened, and including changing judges, including people getting arrested in court, people getting injured in custody, defense attorneys getting arrested, people being held in contempt, the Supreme Court of Georgia being like, what are you even doing? We're not holding this lawyer in contempt. This is dumb. All of it. It was such a wild case. So we're going to watch the verdicts come in on the last 2 defendants, and we're going to talk about it. But this case has been one of the most disorganized shit shows I think I've ever seen. I don't know why they brought it. It's just a really wild case. And look, it is my firm belief that our prosecutorial system, our criminal justice system, only works well when prosecutors also use restraint. There has to be a discretionary decision-making process. I do not like, this is very much my personal opinion, I do not like when DA races become political party affiliated. I think our criminal justice system should be about justice and not about, well, I'll do this and I'll do that. And I feel like high profile cases particularly get stuck in the middle of DA elections. And I do not like it. I don't think cases should be used as political pawns. I think if the case needs to be prosecuted, it needs to be prosecuted. If it shouldn't be prosecuted, then it shouldn't be prosecuted, period. It should not be used for gain. It should not be used for headlines. It should just be, would this community be less safe if we do not prosecute this case? And sometimes the answer is yes. And sometimes the answer is no. I don't know if there's a better system to have DAs. They're elected, which means people can also yeet them out of office, which I think is a good thing. But when there are elections, there is lots of money involved. And then there are promises made. And I don't like it when prosecutors do things based on politics and optics. I do not like it. I do not like it at all. And I don't know how to pull the politics out of that. I think DAs should have to run party unaffiliated. So it should not be a party thing. If they are running for election, it should be, this is how I will make our community more safe. And I hate that cases get used as political footballs. I absolutely hate it. But when politics, and not political party politics, but when elections are involved, there is politicking that has to happen to get elected, which means you have to talk to people. You have to be endorsed by people. You have to raise money so people know who you are so that you can get elected. And when we introduce that process into the justice system, well, what could possibly go wrong? So it frustrates me when cases seem to be politically motivated. And I think that this prosecution was mostly politically motivated, and that's my own feeling. But justice should be justice. So justice should be justice. Will this keep the community safe? I do not like it, but I also don't know the solution to it. Maybe all of us together can come up with a better solution for what DAs are doing. So let's continue on. This was a great question. I saw Chelsea asked in the chat, do you think cameras have increased political motivations? No, because there were always local newspapers that were very involved in courts. And there are local cases that become very polarizing that never have a camera on them. And that's just from my experience. So, Mama Amma said, I wish you had been covering this the whole time. I have covered it in bits and pieces. I could not follow this long of a case. I could not follow these DAs. And honestly, the last judge stressed me the fuck out and made me completely anxious. The courtroom was completely disorganized. The court, it made me anxious. And I couldn't sign up for a whole year plus of just one case. We've had lots of other cases. So I peeked in and out on it. And with peeking in and out on it, I also covered it in quick bits and on the channel. So you can, if you look for YSL or Young Thug, you can find it there. But it was so fucking stressful. So that is why I did not, because I couldn't. I like this judge better. But this case has been wild. So the highlights, we've done the highlights, which works well for me. So, and we do have a playlist. All right, let's just pull up court and do some live court. We'll watch them read in the verdicts on DeMonte Kendrick, aka Yak Gotti, and on Shannon Stillwell. And then we will talk a little bit about that, answer any questions, and then we will zoom to talk about Kari Morrissey. And then we've got some quick updates in the Kouri Richins case. So that's the plan for today. We added this in because, well, it happened this morning. The jury had been deliberating since before Thanksgiving. So they took quite a while, which surprised me, actually. But then again, they were in trial for 150 fucking years. So are we shocked? No. No, we're not. No, we're not. All right, let's make sure we have volume. Oh, we certainly didn't. Well, let's make sure we have volume and let's get rolling. Let's go to court, law nerds. Let's go. Let's swoop. That'll help. And I have coffee. So all is well.
Today, if the state feels like they can do it, I know Adrienne is gone. She's left the body here, but I have been texting with her. We're very close to her. Okay, and that's fine with me, and I'm here all day, and I'm willing to entertain anybody's offers. So,
I think they are getting ready to bring the jury in. No, maybe not.
I don't know if we're right there as it relates to the updated offer.
okay.
All right. Nope.
Honor is available.
Let me see. Miguelina, do you have a timestamp for me for when the jury comes in? Well, is it right after this? It must be after this. Unless it is before this. Hold on. We need to bring the jury. I think it must be a little bit after this. All right. Yep, that's the wrong video. You guys are like, nope, way too far. That's the wrong video. This is not the verdict. This is just verdict to watch. Does the jury come in before? Maybe they do. Oh, yep, they do. This is at the very beginning of the video. Thank you, guys. So they stand as the jury comes in. Let me go backwards. All right. Thanks, chat. Let's go back. I remember this is the jury that one of the jurors tried to leave and said, I'm biased against the prosecution because of the way that they're presenting their case. And another juror was like, I am bored. Like the jurors were not having it. All right, let's go to the beginning as the court comes on the record. There we go.
All right. Good morning.
Bring the jury.
Sure.
So the bailiff is, it sounds like, telling the defendants what they can and
All
can't
right.
do.
Good morning, everybody. We have a verdict. We have two verdicts. And
there's two defendants.
I do not want there to be any kind of disruption or disturbance in court, regardless of what this verdict is. So, can we get the jury out, please?
Bring the jury.
All right. I don't know if it's just me, but the sound sounds like it's clipping, but I think it's on my end. I'm not going to lie, I love the Louis sweater.
All right, thank you very much. All right, ladies and gentlemen, I understand that you all have reached a verdict. Mr. Foreperson, is that correct? All right, and was it unanimous? All right.
Oh,
and
look.
this verdict has been filled in.
She asked the jurors, is it unanimous? Oh, how helpful.
And signed and dated by you, correct? Or for each defendant. All right, and I noticed that Mr. Kendrick's verdict form is dated December 2nd. Is that because that's when you all reached the verdict with regard to him? Okay. And then Mr. Stillwell's is dated today. Okay.
Oh.
All right.
So they had a verdict on the other defendant for quite a while, And it sounds like we're deliberating over Stillwell for the balance of the time.
Kendrick, you have been found not guilty on all charges. Mr. Stillwell.
Not guilty on all
Please
charges.
stand. You have been found guilty on count 64, possession of a firearm by a convicted felon, and not guilty on every other charge.
One guilty for possessing a firearm. Not guilty on everything else.
So,
Because
ladies
again-
and gentlemen of the jury, you are officially released from further service, and I cannot express the degree of thanks that Fulton County owes you for your service. Given the length of this trial, you have paid close attention this entire time.
I'm going to rewind to the judge's comments. But yes, his defense attorney immediately looks like he's going to cry. Immediately, he's like you can see him trying to will the tears back up into his face. Because these are the two defendants. When everyone else took pleas, these are the two defendants that were like, no, we're staying in this thing no matter what happens. And they won. All right. We're going to continue to what the judge has to say to the jury.
Service, and I cannot express the degree of thanks that Fulton County owes you for your service. Given the length of this trial, you have paid close attention this entire time, and I appreciate your devotion, as I'm sure do the parties in this case. You are welcome to stay for the sentencing, or you can return to
they're
the
going to
jury
sentence this morning.
room. I would like to speak with you in just a moment in the jury room. If you all do want to stay, you're welcome to stay. Is there any objection to the form or the legality of this verdict?
They're like, no objection. No objection. We're done. Let's go.
Any from the
No
defense?
objection.
All right. All right. Is there any reason that we can't go ahead and sentence?
So they're going to go ahead and sentence.
You may.
And he's being sentenced. He's approaching, but he's going to be sentenced on just the felon in possession of a firearm count, which after the amount of time that they've been in custody for this trial is probably going to be time served. So we'll zoom to that. But I saw a question in the chat that said, what do you mean he was found guilty on count 64? How many counts were there? 88. It was an 88 page indictment, 55 counts. So yeah, over 55 charges, but those charges weren't to each defendant, and some of them were, so it was staggered. So that's how we ended up there. But I imagine that Young Thug's attorney is like, oh, I told you we had this jury. And I think they did have this jury. I really do. This case was so convoluted. I don't think that it was going to be easily followed by the jury. And that said, though, when you take out the tip of the spear, which in this case was Young Thug, they probably still would have been in trial. Because once he pled out, you pull out everything as to him. All right, let's continue on and see if we get them to, if we get to sentencing right now. I imagine that we will.
Are we going to go ahead with sentencing? Is the state, I know the state had filed a recidivist notice. Yes. Do y'all intend to stand on that? Yes. All right. So the recidivist is A and C recidivist. That means that I have no discretion but to sentence to the maximum on that count. And the sentence possibility is 5 to 10. I must sentence to 10 years. However, I can probate any part of that sentence at my discretion.
So what the judge said is because of the recidivist statute, because he was convicted of felon in possession of a firearm, which means he has previously been convicted of a felony and then was convicted of the next felony. I don't know what the standards are for Georgia's, if it's just one or if the recidivism needs multiple charges. Every state does that differently, whether you need one conviction or if you need a bunch of convictions. But the state filed that, and so it forces this to be maxed out, which is 10 years. But she said, I can probate that, which means a term of probation.
And so the court sentence on count 64 for Mr. Stillwell is going to be 10 years to serve 2, with credit for time served, the balance served on probation.
So he's
right,
out of
I'm gonna-
custody. He's out of custody. The judge sentenced him to 10 years time served, which means the amount of time he's been in, and then probation, which for a felon in possession of a firearm, 2 years seems about right.
Recess.
All right. And they are done.
Recess for a moment, and we will reconvene on the status conference in a few minutes.
So they are done. For the most part, both Shannon Stillwell and Yak Gotti Monte Kendrick were acquitted of almost everything. The only thing that Shannon Stillwell wasn't acquitted of was felon in possession of a firearm. And that's probably because they had really solid evidence of him having a prior felony and then at some point having a gun in his hand. Is that incredibly difficult to prove? No. Do those cases go to trial very often? No. They plea out and deal with other stuff. So, what does this mean for the other defendants? Well, for the other defendants that took plea deal, it doesn't really mean much because they already took plea deals. And the evidence is different as to every single defendant. But I imagine that if you are Young Thug and his attorney, Brian Steele, you probably feel like vomiting. But I think Brian Steele knew that this was going to happen. And Brian Steele very much felt that they would win if they continued on with trial. I think that's got to be one of the very hard things about being a defense attorney is there are things that are just not your choice. As a DA, quite a lot of things are your choice. Sometimes your bosses try to make it their choice, but even then you have a choice. But as a defense attorney, when your client's like, no, I'm taking this plea deal, there is nothing you can do to stop it except say, please don't do that. That is not, do not do that. But if they're saying, no, this is what I'm going to do, then that's what they're going to do. So that is really it. A number of you are saying the judge comes back out, keep going. So I will zoom to the judge coming back out and we will see. But I do not know if there's anything else we need from this court today, but she does come back out. I'll take a look. But I also want to go to the interview of one of the attorneys. So I think they are probably pretty upset. You guys are like, keep watching. All right. Well, I trust Chad is Bay and I trust the Lawnards. So we'll see what happens. Let's see. Let's go. Oh.
Various computers to see that she wasn't down there. She did tell me she was running out though, so that's my bad.
Terrell Dark, is he here?
All right, let's see what happens.
All right, so the Rule 22 was filed mere minutes ago, which is why I didn't have any notice of it.
Who is doing that?
She forwarded me something I was sent.
The judge had advised everyone that there were not to be any outbursts in court, but yes, defendants crying does happen, but the judge had advised everyone that there weren't to be any outbursts. It doesn't always stop it from happening, though. But generally, they are advised, and it is something that is more unusual. But it does happen. There are times that there are very large outbursts. Generally, I've seen that more at sentencing than at verdict. At verdict, normally people are kind of stunned, but at sentencing, you can see a little bit more. I'm not surprised that the defendants hugged their attorneys and looked like they were going to cry, but there was no verbal outburst. There was nobody fell to the ground in sobs. It was very, very subdued celebration. But also, you have to wonder in a case like this, if the jurors are looking at the defendants, because you saw one defendant just give the, you've got me, guys. I wonder what the defendants were seeing from the jury when the jury was looking at them. Because I wonder if the jurors were looking at the defendants, just nodding their head, just being like, yeah, we've got you. Because sometimes when they come out with guilty verdicts, the jury is staring down the defendants in a, we know what you did. Sometimes you can tell. So this was incredibly subdued. But yes, I have seen outbursts. This was a reaction. All right. Let's see if there's anything in this status conference we need. Otherwise, we're going to just zoom and get into talking about Kari Morrissey. This case isn't done. There's still a ton of other defendants.
Well, what I am looking at,
the rotten hell was, I don't know if it was Murdaugh or if it was Daryl Brooks, but I think that was at sentencing. Sentencing tends to be a little bit more volatile.
actually says that they would like to record proceedings that commence tomorrow. So and that's from Atlanta News First. That's the only one that has been forwarded to me, is requesting something starting tomorrow, which obviously would not cover today. And
I think it was Daryl Brooks. Oh no, Kari said, I think it was Vanderpump Rules. No, that's not rot in hell. That's rot in hell. I can't Alabama it the way that Brittany did, but it was more of there was a W in there somewhere. She's talking about recording.
It was forwarded to our public information office at 10:16. So there does not appear to have been any kind of Rule 22 even filed at the time this proceeding started at 9:30.
Dear.
That, regardless, you can tape under the circumstances that you and I already discussed. Just make sure not to show the defendants because they're not dressed out in civilian garb, if you will.
I think that's fair.
All right. Thank you.
Here's the thing. They had recording permissions. Sorry, Your Honor. They had recording permissions for the YSL case that just finished. But that case, for the hearing that just finished, what she's saying is they didn't have recording permissions for the next part of this case. And the next part of this case is what is starting now, which is the other defendants. And so she's saying, look, under the circumstances, you can record, but don't show the defendants. And that's appropriate because, the defendants aren't dressed out. And we've seen this come up in other high profile cases where the defense attorneys are very mindful of showing the defendants dressed in jail clothes, not in civilian clothes. And we've seen that argued quite a lot in the Koberger case. If this is a high profile case, then we want to make sure that the defendants are being shown, not in a way that could potentially influence any jury member. However, no juror member should catch clips of this on TV, but it's likely that they will see a clip of a defendant. And then, you don't want to leave an impression in their mind that somehow because they're dressed in jail clothes, it means that they've done something wrong because they are innocent till proven guilty. So that's part of where we're at with all of this.
Court reporter. And so before we were officially on the record with the court reporter, I had let everybody know about the verdict, that it had been returned in the trial that was ongoing until a few minutes ago in Mr. Kendrick and Mr. Stillwell's case.
Right.
And it may be that new offers will be forthcoming to some or all of you.
They should be.
It may not be. I don't know. That is not.
I don't think the government is going to all of a sudden reevaluate their situation. I have a feeling that this prosecutor's office is just going to double the fuck down. I have no confidence at all. I really don't like this prosecution at all. I have no chill about it. I don't like it. I think it's overreached. I think it was overbroad. I think trying to use the RICO statute when states have gang statutes that are specifically to address gang activity is, it's just a gross prosecution. It's just a gross prosecution. If you want to prosecute somebody because they are a felon with a firearm, go prosecute them for being a felon with a firearm. If you need to prosecute somebody because they're selling drugs, go get them for dealing drugs. But when you try to turn the entire thing into a massive state level RICO case, and it's just not, to try to pull in all of the other information, it's not a good use of RICO. It's just not the way it's supposed to work. However, juries generally get it right. And the jury probably sat there looking at the prosecution. I can see a jury sitting there, and in their brain, they're just like, you had us here for almost 2 fucking years. This case started jury selection in January of 2023. They're like a month shy of 2 years. It was a year of evidence because opening statements started in November 2023 to verdicts at very beginning of December 2024. And yes, there were defendants who needed healthcare because somebody had gotten stabbed in custody. There were people who had gotten COVID. Like, there were large gaps. There was a judge that got completely kicked off the case. I hate this case. I hate it for these defendants. I hate it for the taxpayers of the state of Georgia. I hate it for these jurors. I hate everything about it.
For me to decide. That is for the state to decide. And the charges against some of you are very serious. Some of you are charged with murders. Some of you are charged with other very serious felonies. Some of you are just charged with RICO or gang counts. Those are serious as well. I don't know what if the state is going to regroup and take a new tack. I have no idea. I would imagine.
But they should. Isn't that the subtext? I don't know if the state's going to regroup, but they should.
Imagine they'll be talking. And I'm just wondering if it might be a good idea to set maybe a new date for a final plea again. I know y'all had a final plea once in front of a senior judge. It wasn't the judge that was going to preside over the trials.
Who's now you?
I'm happy to do that.
All right. I think they should. I'm going to stop there. If anything else happens, we'll summarize it. Allie said, why was the judge kicked off the case? I forgot about that. I covered it. So we've got a whole YSL playlist. I'm not going to reset the entire case, but it was a mess. There was a lot of reasons that the judge was kicked off, but it's actually kind of nuanced. And I don't want to understate it, but there was a lot of fuckery in this case. That is the best summary I can give. There was a lot of fuckery in this case. Kari said, wasn't Brian Steele held in contempt? He was. And he was like, look, Brian Steele's a fucking G, man. Brian Steele was like, if you're going to put me in jail, can you at least put me with my client? Can I just bunk with my client so we can work on trial? Just bunk us together. That's all I ask. Just let's go. Like, Brian Steele is a ride or die criminal defense attorney. And I imagine that he works with a lot of high profile defendants. And it seems like he has worked with his client, Young Thug, for quite a while. And they had a very good working relationship, which is why Brian Steele seemed absolutely heartbroken that his client wanted to take a plea deal, because he was like, no, you could see his soul like leaving his body. But I covered that on the podcast too. I wanted to look at the attorney's interview because I find them so interesting. And we have a brief interview with one of the attorneys. I don't know if we get both of them. This is coming from Atlanta 11 Alive, I think is where we're grabbing this from. But I want to take a look at this statement. For all of you asking, does Young Thug have the option to redo his plea? No. This changes nothing about his plea other than the level of heartbreak for both him and his attorney. But no, it does not change. It does not change his plea. So let's go to this. Amy, it's good to see you in the chat.
About turning his life.
All right, let me see if I can gain the audio on this up just a little bit. And let's see if it will help. Maybe yes, maybe no. But it's a little quiet on my end. All right, let's see what his attorney has to say.
30-year-old.
There we go.
About turning his life around and having a second chance at life and making it mean something and being there for one's children and for one's family. So I'm just so happy, excited for Shannon. I'm happy and excited for his grandmother, who I was able to hug, and I'm happy for his kids, and I'm just very hopeful that this is a turning point and there's great things coming in the future.
Max, is this a fair and just verdict, do you think?
Absolutely. Absolutely. The jurors, we asked so much of the jurors, and they really scrutinized the evidence, and they demanded real evidence, and it wasn't there. And so we are thankful for the jurors, and it's just a great day.
Did you have a chance to talk to the jurors?
I did, and I'm not going to comment on the discussions with the jurors, but I will.
Sir, that's very honorable of you, but damn it, we want to know. Damn it, we want to know. Jolene in the chat said, in responding to NDog in the chat, Shart is a last name. Yes, one of the attorneys in this trial's last name is actually Shart. This trial is a whole situation.
Just say, I think the fact that they deliberated for 4 days, and also that just the amount of time that they put in, they certainly scrutinized everything.
Yeah, they
and
did.
Did their jobs as jurors, and we are appreciative.
I'm sure
of
he
that
is
and so
thrilled.
thankful.
Can you reiterate again what only found guilty on one charge and what that means for?
This is a rare thing for a criminal defense attorney to have a day like this. This is a couple times in a career type of a thing. You don't generally see high profile cases, especially going this direction. It is very, very rare. But again, prosecutors should exercise discretion. And when they don't, juries are kind of the last bastion of fuckery. And at one point when prosecutors are like, we're going full steam ahead, the only people that can tell the prosecutor's office to knock it off are the jurors. And the jurors shouldn't, I think, be put in that position. You shouldn't bring a trial that shouldn't. Emily, are you going to say you shouldn't bring a trial that shouldn't be brought? Yes. You shouldn't. And when you see prosecutions and you're like, what the fuck are you doing? It's normally a high profile case. But they were facing multiple indeterminate life sentences on this indictment. So yeah, this attorney is thrilled that his client got convicted of felon in possession of a firearm, probably because he was just A, a felon, and B, was with a firearm. There's not much you can do, but it also shows how thorough the jury went through this and said, yeah, that one has evidence. This jury didn't just say, fuck you to the prosecution. They said that one has evidence and these don't. That's an incredibly thoughtful verdict. That's not a, we're so over this case, we're not going to think it through. This is a jury that took their time They didn't just say, fuck this prosecution, just acquit them on everything. They clearly went through the evidence and said, yeah, on that one, there's evidence. Good for them. All right.
The future, him getting released, all that stuff.
So he was found guilty of possession of a firearm on March 17th, not the day of any other crimes. It was the day that he was arrested.
Okay.
Oh, so he had,
and there was a gun that was registered.
There was a gun in the car.
To his girlfriend.
Yeah, if you're a felon, you can't have a gun. It doesn't matter if it's your gun or not your gun. You can't be in the vicinity of a gun, which if you guys go back and watch on the playlist, when I talk about the conditions of probation for Young Thug, you're going to see some of my concerns with his probation feeling a bit like a trap. But okay, so the day he was arrested, he has a gun in the car and he has a felony. Do you know how they prove felon with a firearm? Emily, have you done a lot of these cases? Yeah, they come up all the time. You just bring in their priors and go, those are felonies. And then that's you with a gun. That's it. A year of trial for a case that if it went to trial on its own would take one witness and about 45 minutes after jury selection. But it would never go to a jury unless there were other things happening. Because they don't.
That was found near the scene of where he was arrested. And that's what he was convicted of. Judge Whitaker, we are so thankful to her for having an open mind. A lot of times when you take a case to trial, you just get the maximum sentence for daring to take on the state. Judge Whitaker did not see it that way. She gave Mr. Stillwell.
Judge Whitaker will never say this out loud, but I think Judge Whitaker fucking hates this case. I think Judge Whitaker is also really unhappy with how the state is behaving in this case. And you should not get more time because, as he said, you dare to take on the state and take a case to trial. You shouldn't. And some defendants feel that way. Some judges feel that way. It's like, you went to trial, but you shouldn't get more time. You have a right to a trial. You shouldn't have more time ever for exercising your rights. The thing is, when you go to trial, let's talk Sarah Boone, for example. When you go to trial, the judge has the opportunity to see more about the case. And if Sarah Boone had taken a plea deal, the judge never would have seen and heard all of those videos of her abusing, berating, mocking, attacking her victim, George. The judge never would have seen it. But when you go to trial, it all comes to light. And the more the judge knows about you, the less likely it's going to go well for you at sentencing, unless it's not a righteous prosecution. And then you're going to end up here. So I think that's why Judge Whitaker's like, time served, go. The time served, be on probation. You're a felon. You know you can't have a firearm, don't have a firearm. You can't be around people with a firearm. Just, you have to follow the rules. But not this.
Well, time served sentence for the time that he is served, followed by probation. Mr. Stillwell has a couple, or I think one other criminal matter that needs to be resolved. I am hopeful and optimistic. It's nothing like this case.
I got totally distracted because a woman just walked into the court with a glorious jacket and purse combination. And I was like, ooh, I saw the caramel colored jacket walking up the stairs. Totally distracted.
It's a case that was picked up while incarcerated.
Well,
and we're hopeful that there will be a quick resolution to that case.
I'm sure there will be.
Mr. Stillwell will be able to get back to his life and his children and his family.
You think he'll be home by Christmas? Is that
I'm hoping. Okay. That's not unrealistic.
So Mr. Stillwell is not walking out of custody today because he picked up a case in custody. But seeing that one of or multiple other defendants in this case have been stabbed in custody, it's not been easy in custody. And it doesn't mean that there isn't other shit going on. All of you are like, rewind, I want to see the jacket. Okay, we will. Nebraska Jeff said, can the state appeal the sentence? I mean, they shouldn't. But no. I mean, yes, they can, but no, they shouldn't. No, they shouldn't at all. No, they shouldn't at all. A lot of you have asked, do the jurors get paid? It depends on the jurisdiction. Most jurisdictions, it's like $10 to $15 a day, but jurors can't be fired from their job. So I would imagine that all of these jurors are in the types of jobs where they work for a company that's large enough that when they work for a company that's that large, they still have to pay their employees. So they probably are still getting paid. I would be curious as to how many jurors are government employees, because government pays their employees for jury duty, or work in larger corporations. But somebody who's self-employed would have probably been exempted off of this jury for hardship. And that's a whole nother conversation about, do you get a fair jury if the only jurors you can really have are government employees? Like, is that fair too, when you have a jury for so long that almost anybody can't afford to do it? But there also, in this case, were large lapses of time where jurors could go back to work. So when court was dark for like 2.5 months because the judges were changing over, the jurors would just go back to work during that period of time. So let's see. But yes, they would pay. But this is the other problem. Plant Hoarder said, my job would be so mad to pay me for 2 years of me working jury duty. Yeah. But there definitely were times when this court was dark and they would get to go back to court. And some of you were saying some of the counties in Georgia pay $30 a day, $25 a day. That's better than most jurisdictions. So that's what it is. But these would have to be jurors with a employee or a employer that pays. And that's it. So Casey Cat said, I served on a 6.5 week quadruple homicide case and got paid $7 a day, right? Which doesn't even really cover lunch if you work in a jurisdiction that doesn't provide lunch, because there's a lot of jurisdictions that do not provide lunch. So it's not easy. But when I was a government employee, there were times I'm like, can someone just put me on a federal grand jury? It can be civil. Like, I'll sit on a civil case. There were a couple colleagues who got pulled into larger civil cases and they were gone for like 3 months. And they're like, bye everybody, like files on the desk. Like, I'm out, I'm going to jury duty. I'm like, damn, that would be amazing. You still get paid. You don't have to go to your job. You get to go watch somebody else do their job. Oh, that's basically what I do for a job now. Look at that manifestation. I'm going to listen to the rest of the questions and then we'll back up and see if we can see the coat. No, let's go see the coat. Let's go see the coat. And then I will zoom. Where did it go? Oh, I can't zoom because it happened so fast. Hold on. Let's see. For those of you asking, Emily, how are you feeling? Tired. It was a late night recording the podcast. Wait, there's the coat. There's the coat. The coat up in the corner over the cell phone.
Criminal matter that needs to be resolved. I am hopeful.
So good. Look at that coat. Gorgeous color caramel. Love the bag. 10 out of 10. Courtroom fashion. Peak. I got distracted. All right, let's continue.
It's nothing like this case. It's a case that was picked up while incarcerated. And we're hopeful that there will be a quick resolution of that case and Mr. Stillwell will be able to get back to his life and his children.
Yeah, and the heels.
His
so good. All of it was so
He'll
good.
be home by Christmas? Is that
I'm hoping. Okay. That's not unrealistic.
I know you don't want to get into exactly what the jurors said, but what do you think their one sticking point was?
I don't think there was.
I'm so sad that we didn't get into what the jurors said, but it's admirable. I just want the tea.
One sticking point. I don't think there was.
Yeah, I like the scarf too.
So many people have been watching this case. In opening, I said from the beginning about the
this is
witnesses.
By the way, this is not the attorney who opened talking about anime. I don't know what happened to that client. At some point, that defendant was no longer in the case, but one of the attorneys did do a whole anime opening. It was a moment.
In blue suits and wearing the Fulton County Blues, and I think the world got to see how cases can be built the wrong way. Just finding people that are prone to lie and talking to them at their most desperate time to try to get them to say.
Yeah. When you have a witness get on the stand for days and say, I'm telling you, I told the detective whatever the fuck I thought he wanted to hear so that I could go home. I don't care if it was the truth. An entire witness. No, I lie. This whole witness sat on the stand. I lie. I lie to the defendant. And then the prosecutor would be like, is this, but that's the truth. It's like, well, that's how you lie better. You put in a little bit of truth and the rest of it's lies. That's how you lie better. I told the detective whatever the fuck he wanted to hear. At that point, the jury has to be like, are you fucking joking me? That this is one of your key witnesses. The Woody defense witness was wild. But you know what? When he came into court and was like, no, I lied. I lied and lied and lied and lied and lied. And I lied because I wanted to go home and I didn't give a fuck about all them. I wanted to take care of me. That's the truth.
Say things about other people, and I think that's what happened here, and I think the jurors recognize that. And of course, regarding the 2022 case, that was on video, and I think we explained what we saw in the video, and I think the jurors likely saw the same thing.
What kind of message should this verdict send to the taxpayers of Fulton County?
That you need a new DA. What kind of message should this send to the taxpayers of Fulton County? This attorney might not say it because he still has to work with their office. But the message should be, is this where you want your money going? Is this what you want your prosecutor's office doing? You know, is this what Atlanta wants their DA's office doing? Maybe it is, but I doubt it. But y'all make a good point in the chat. She did get reelected. So...
Oh, I don't know about all that. The message that was sent to me is my.
Very smart, counsel. Very smart. He can't really go into it because this is where he works. I can.
Client has a second chance at life, and we're just so thankful for that. And I know he is. And we are also just so thankful to the press for covering this, and all the people that at some point the public began to root for us.
Yep.
And that did make a difference, and we appreciate all the people that have been supporting us throughout this process this long.
I think the jury or the public started to root for them the more people saw what was actually happening in this case. Because again, when you look at a case, here's the thing that makes me mad about the media a lot of the time is the media. I think a lot of legacy media treats people like they're stupid. I don't think people are stupid. I think that when you show people what's going on, which is why I think there should be cameras in courtrooms, when you show people what's going on and allow them to question what's going on, a lot of time people are like, wait, what the fuck is happening here? And then when you look at a case like the Darrell Brooks case, like the Sarah Boone case, where the evidence is incredibly strong, you look at that case and go, yeah, you did that. Go to prison. Don't get out. Bye. But when you look at cases like this, you look at this case and go, what the fuck are you doing? What are you doing? And that's fair, but that's why they need cameras in court, because I think people should be able to see as much as they want to see for themselves. And if people don't want to watch court all day, don't. But if people do want to watch court all day, do. You get to choose. So, and I think when most people started actually seeing what was happening in this case, they were like, this does not smell right. And I think people have a lower tolerance for government fuckery. That doesn't offend me at all. I think we should have a low tolerance for government fuckery. They have a lot of money.
Journey.
Can you speak to the conditions in the jail?
Oh, he's asking about conditions in jail.
And I don't mean to.
Okay.
We know that Shannon was stabbed in the stomach earlier in this trial, while this trial was going on. We know we had to break for a week, or at least a week, might have been 2 weeks. For
yeah, it was a while while he was in
recovery.
recovery.
Allowed to go see him in the hospital, and so that was, and then Mr. Kendrick was stabbed in the head recently. So obviously those are serious, and we got to make sure we take care of people, especially people that aren't are not even convicted of anything. And so that's I think it's something we need to address. I'm not blaming any particular person, but it's something as a society and as a city we need to take care of.
Yeah, jail can be dangerous. Absolutely. Which is part of the problem, right? So, with all of that, I see a number of you in the chat saying, yes, the current DA in Atlanta, or the DA that started this case, did get reelected. I don't know who she was running against, so I don't know. Aaron said, what, there was a stabbing in custody? Multiple defendants in this case were stabbed in custody. Multiple defendants. So there were a multitude of stabbings that happened in custody in this case. It is not an uncommon occurrence. Brian B said, Emily, why wasn't there a jury poll post verdict? There was a poll before. The judge didn't poll individually, but the judge said to all of the jurors and looked at them, is this a unanimous verdict? And they all assented in some way, maybe nodding, maybe not. And then they moved on. And then with the not guilties, the defense attorneys did not ask to inquire further from the jury. And so there was a very general, is this your unanimous verdict at the beginning? So with that, I'm going to look for a few other questions. Alamonix, yes, Brian Steele's contempt charge was overturned by the Supreme Court. I think we talked about it in quick bits. Casey Cat, thank you for the gifted memberships. Andrea, thank you for the super chat. Malleus Maximus said here, Brian Steele sits with a broken heart. Tried to sit through, but at the end, only shart. Yeah, I think Brian Steele is probably a bit gutted by all of this. I really think so. And let's see. Happy at Heart said, does Thug have the option to redo his plea deal too? No. Do the jurors get paid for the 2 years? I know we talked about that. Kelsey said, oh my God, my hoodie was delivered, so I used my lunch break to go home and pick it up. I love it so much. Thank you. You're welcome. Aren't they soft? They are so cozy. I promise I'll wear something else again, because they're just so cozy, and it's snowy out. Well, the snow is just starting to melt for the day, but it was snowy out. We need to go talk about Kari Morrissey, don't we? We need to go talk about Kari Morrissey. So we're going to talk about Kari Morrissey, and then we will, let me check. I'm waiting on I am trying to find one thing with regard to Kouri Richins that I am waiting to see if I get, but we will talk about Kouri Richins at the end, as I am waiting for something from the court. And if we don't have it today, we'll talk about it Thursday. Either way, we're going to talk about the Kouri Richins ruling, but we need to talk about Kari Morrissey. Because Kari, what are you doing now? Like, why? Just why? Just why? I was very surprised to go on to the docket and see that Kari Morrissey had filed a notice of appeal, appealing the judge's ruling with regard to the judge's denial of the motion for reconsideration of the judge's dismissal of Alec Baldwin's deal. So for a quick road so far, you guys watched Alec Baldwin's case get dismissed with prejudice by the court as a sanction for Brady violations by the prosecutor for not turning over evidence. We all watched that go down. Then the judge put out a very thorough written ruling. Then Kari Morrissey, at the 11th hour, filed a motion for reconsideration that was substantially over limits. The court denied the over limits motion, and Kari Morrissey filed a pared down motion. The defense responded and said, hey, this is late, and hey, she should be sanctioned, and hey, no, we shouldn't do this. And the court denied, like swiftly and fervently without oral argument, denied the motion for reconsideration. And now, Kari Morrissey is saying, hey, I'm going to ask the appellate court to reconsider this dismissal. The fact that she is trying to go through this again is absolutely bananas to me. Bananas to me. So let's pull up the order. Well, no, the notice of appeal and go through it. I am so over this. Emily, are you okay? No. What? It was dismissed with prejudice. There was so much Brady violation fuckery. Why are we doing this? But also, I did not read it in advance. So we are going to go through it together. Because we are going to go with it together. I saw, let me grab this question in the chat. Can we start at Code Green? No, we're going to have to see if we get there. Monuments of Speculation said Morrissey's obsessed with Baldwin. Can't let it go. Can't let it go. Purette, I think I pronounced that properly. Hopefully. Does someone know if this means Alec gets away with this? I mean, his case got dismissed with prejudice because of the prosecution's bad behavior. So I don't know if it means, well, yeah. I mean, it means that he can't be prosecuted for it. So when his case was dismissed at trial, that's what that meant. Do I think that the appellate court, I'm going to see her arguments. They're going to be the same, I imagine. I haven't read it yet. But do I think that means that Kari is going to get another shot to try Alec Baldwin again? Probably not. I don't think this is going to go well because I think the court was right. And Kari wants to keep saying, you don't understand. It was unintentional, Your Honor. This was not intentional. And the Teskey rounds don't have anything to do with this case. Kari seems to be stuck in a loop of these bullets don't have anything to do with this case. And the court's position is, okay, babes, you're not hearing me. It's about the fact that you didn't turn them over to the defense and they were in police custody. That's the point. The Brady violation is the point. And Kari Morrissey's like, but Your Honor, there's no Brady violation because they're not relevant to this case. And the court is like, but the defense needs to have them and you didn't give them to them. And then they were put under a different case number. So the defense couldn't even ascertain if they existed. And this was not the first Brady violation. The fact that she wants an appellate court to look at this is wild to me. Wild to me. But here we are. So here we are with the notice of appeal, because why not try again? Oh, we got to get rid of our live court. We are no longer in court. We have courted. Hold on. All right. What in the world? Well, that's not the right one. I'm like, that doesn't, I mean, it's the right document, the wrong window. Let's see. We need it to be full screen, please. There we go. There we go. Let's try that one more time with feeling. All right. This is Kari Morrissey's notice of appeal. This was filed November 21st, but right before the Thanksgiving holiday, it was quite busy. And so Kari had to wait a minute. She needed to sit down. She's not gonna, though. Kari's not gonna sit all the way down on this. It's just not gonna happen. This might go, no, that's worse. Let's see. We can zhuzh me a little bit over to the side so that this is easier to see. All right, let's do that. All right. Notice of appeal. The state of New Mexico. I mean, the state of New Mexico is like, can you leave us out of this at this point? Please. And Kari's like, no, we're not done yet. She's like, I'll never let go, Alec. I'll never let go. I'll never let go. The state of New Mexico, by and through special prosecutor Kari Morrissey, appeals to the New Mexico Court of Appeals from the court's order granting defendant Alec Baldwin's expedited motion for dismissal and sanctions under Brady Giglio. I mean, wouldn't she technically be appealing the reconsideration? Maybe not. Let's continue. Oh, she just attached the order. No, that's Kari. Where is the rest of the appeal? I thought she had attached her motion for appeal. She just attached the court's order. No. Let me go find the rest of her appeal, because just the notice of appeal is not very helpful. Let's see. So both. So the state of New Mexico, by and through special prosecutor Kari Morrissey, appeals to the New Mexico Court of Appeals from the court's order granting defendant Alec Baldwin's expedited motion for dismissal and sanctions filed on July 31st, and from the court's order denying, there it is, Emily, keep reading, and from the court's order denying the state's amended motion to reconsider dismissal with prejudice filed on October 24th, copies of which are attached here too. But let me go find her motion. Maybe her motion's not filed yet and she only filed her notice. I'm going to go take a peek real quick and see if I can find it, because we need it, but she's just not going to let it go. And it might not be in yet, which is fair. She might have just filed the notice of appeal, because I didn't read through it. I only saw the headlines, and it was very late by the time I finished the podcast recording yesterday. And then she attached both orders to it, which is why I thought she had attached her memorandum. But let's see. She's I'm shocked that she's trying to do this. I really am. Why? Why, Kari? Why? Now, Silent Bob, now. Let's see if we can find it together, and then we'll talk about Kouri Richins real quick. Let's see. So now we're going to research stream with me, because why not? I want to see if she filed the full briefing of the appeal. Why not? But I only saw the headlines, so that's what I get. I did say today was going to be a bit of a shorter stream, and then we ended up going sideways into the YSL verdict, so that's totally fair. Christine said Morrissey let this get personal. Yeah, Morrissey got real mad. Real mad. So it's wild. Let's see if it's been filed, because if it has, we should be able to get it real quick. So thank you court for hanging, or court chat for hanging with me for a moment while we try to grab the Court of Appeals document, which I do not see. Nope. Yeah, I do not see the filing from the Court of Appeals. So I think she only filed the notice. I don't think she's filed her full briefing yet. So I'm going to have to wait for the briefing to come in. I thought she had attached it. She did not, and that's on me. So apologies, chat. All I see, I do not see her full briefing. I only see the notice of briefing. That's really annoying. But also, it is what it is. I'm shocked that she's appealing. I mean, I guess I shouldn't be shocked that she's appealing, but her brief is going to say, but those rounds have nothing to do with it. But I don't know what her standard's going to be. Like, what are you doing? JM, she's already been paid. So I don't know what she wants at this point. She's just mad. And I think she really wants, I think she's still stuck in trying to explain herself. She's like, but you don't understand, but you don't understand, but you don't understand. So her argument is over here and the court is over here, and she cannot see what the court is saying. That's what it feels like to me. So her brief will probably be in 30 days from filing of notice of appeal. To file the appeal should be right around that timeline. So we should see this at the end of the month. It's annoying to me that it's not attached because I thought that it was, but that's, again, completely on me. So we can talk about Kouri Richins. Kari Morrissey's appealing because she has no chill. Is this a time when she should chill? Yes. There should be chill. There should 100% be chill on this. But the Court of Appeals is going to have to say no. And I imagine the defense is going to ask for costs again for the cost of this appeal. I also would like to know the grounds that she is appealing the dismissal with prejudice on. I would like to know what her legal grounds are for this. So we will see. Let me check one more place and see if I see it, because I don't see it on that website. Let's see. And see if we see it anywhere else. I do not see that anyone has the actual memorandum. It looks like all of it is just the notice of appeal. Let's see. Well, we do have a statement to deadline from the defense attorneys. So let's take a look at that real quick. Because I'm really curious. I'm really curious what Mr. Spyro has to say about all of this. Also, in a strange turn of events, the Rust film did just have its premiere, which is absolutely wild to me. All right, I can't pull this up if I can't find reader mode because there are so many ads. Oh my goodness. All right, we're going to have to pull this up at a different browser. Because yikes. I mean, I'm sure whatever TV show they're advertising is fine, but good Lord. All right. Let's take a look at what the attorneys had to say, shall we? Why not? Emily, we're running our stream today like a React streamer. I know. We're just doing the things. Why not? We were in court all day yesterday and recorded a podcast. Some days are just like that. Alec Baldwin's lawyers slam corrupt prosecution after latest effort to restart dismissed Rust manslaughter case. Update. Yeah, I'm not surprised by this. Are you? Are you surprised? Updated at 10:58 a.m. and this was updated the day this went live, which it seems in reader mode we can't see, but this was about 5 or 6 days ago. The Rust special prosecutor may have hopes. I mean, never has there been a more Hail Mary type Hail Mary. The Rust special prosecutor may have hopes of reviving the involuntary manslaughter case against Alec Baldwin, but the Emmy-winning actors, can we not? But the actors' lawyers don't seem to be pausing their Thanksgiving preparations over this latest move by Kari Morrissey. Yeah, they don't give a fuck. They're like, she filed a notice of appeal. Okay. We sincerely doubt Attorney General Torres will be pursuing this appeal, which would only further the unethical and corrupt conduct that gave rise to the court's dismissal, defense attorney Luke Nikas and Alex Spyro told Deadline on Wednesday of the action in the New Mexico courts. So this would have been last Wednesday. A day after Morrissey filed notice of appeal, the reaction from the duo kind of says it all for them and their increasing public client. What does that even mean? That's awkward. I mean, I guess that it does kind of say it all, but I don't even know what that sentence means. All right. And Baldwin, who was facing 18 months behind bars if found guilty in the 2021 fatal shooting of Rust cinematographer Helena Hutchins. As it was, Judge Summer tossed the whole thing just a few days into Baldwin's trial in July after a successful defense move that saw the fractured prosecution accused of suppressing evidence. That's not exactly an accurate recitation of what happened. It was a defense motion, and the prosecution at that point had been going pretty well for them. And then the Brady violation. It should be noted that Summer has rejected a number of efforts so far by the prosecution to get the case going again. Well, one, which is pretty clear why Morrissey, Is this written by AI? Which is pretty clear why Morrissey had upped things to the New Mexico Court of Appeal. Was this written by a human? I hate this. I just wanted now we're rage reading. I just wanted to hear what the lawyers had to say, but I've never, what in the world is with this Deadline article? It's like a bad voice to text to my phone. Previously on November 26th at 9:41 a.m., if Alec Baldwin thought he had put his legal woes from the fatal 2021 shooting of Russ cinematographer Helena Hutchins behind him, the special prosecutor still in charge of the matter once again wants the indie Western star and producer to know it ain't over. At least not yet. She wants to appeal. That's all. The state of New Mexico, by and through Special Prosecutor Kari Morrissey, appeals to the New Mexico Court of Appeals. We just read that. And that was in their public notice. While this may be another Hail Mary, no, it is, by Morrissey after repeated rebuffs by Judge Summer since dismissing the involuntary manslaughter case against Baldwin just a few days into his trial in July because of evidence suppression, it once again finds Baldwin under the judicial sword of Damocles. I'm fucking out. I'm out. You know who's got really good snappy writing? Spyro. Yeah, she wants to appeal. His attorney said they don't think that the state's attorney general will take it up. And that's possible, that the attorney general might say, no, we're not appealing it. But I hate everything about the way this article's written. It doesn't read like it's written by a human. And I appreciate the statement from the lawyers, which is, why the fuck would you do this? Because Spyro's great. If Spyro had written this, it would be a, Kari Morrissey is obsessed with whom she calls a cocksucker, Alec Baldwin, and will not let this go despite her numerous failed attempts to prosecute Alec Baldwin or something, because they will continue to bring up the fact that she called Alec Baldwin a cocksucker. That's going to happen repeatedly. All right, so notice of appeal. We'll see if the actual filing happens, but the notice of appeal has to be filed within 30 days. So this might just be her trying to hold time. Lyndon in the chat said, Kari Baldwin is the darkest timeline. It really is what happens when we shift into a different timeline. But that article made my brain hurt. I hate it so much. So we will see if Kari Morrissey is able to and allowed to continue pursuing this appeal. I don't know what grounds she would be using this appeal for. I hate it. So, all right. Miguelina, yes, I'll try to summarize both of the last two things that we've covered because I have not done it yet, and I have not done it well because my brain is still buffering from yesterday. I mean, honestly, my brain is still buffering from Sarah Boone. And I'm sure that's how everyone who has to interact with her in real life feels. I'm just like, what is happening? So, in court, in the YSL case, the morning of December 3rd, the jury, who had been on jury duty for almost 2 years at this point, came back with not guilty verdicts for, I didn't want to get them in the wrong order, came back entirely with not guilty verdicts for defendant DeMonte Kendrick, aka Yak Gotti, and came back with just one conviction for Shannon Stillwell on a felon in possession of a firearm, an incident that stemmed from the day that he was arrested. The judge then sentenced him to the maximum under the law, which was also statutorily required, and the court made a very thorough record that this sentence was required by law. He was sentenced to 10 years, 2 years time served. Actually, it ended up being a little bit more than 2 years time served, and the rest of it to be served on probation. However, he does still have a case that he picked up while he was in custody that has to be resolved before he will be released from custody. But his attorney did say after court in a press conference that he believes that his client Stillwell will be home by Christmas. And that really is fairly realistic, saying we are just at the beginning of December, and anything that was picked up in custody will probably also get time served concurrent with probation. I imagine that they will do that tomorrow or within the next few days. So with all of that, can the other defendants who took plea deals reopen their plea deals? No, their plea deals are done and different evidence went to each of the defendants. Do I think that Young Thug's attorney, Brian Steele, is probably sitting there going, this is what I thought was going to happen? This is why I didn't want my client to plead? Probably. But also, there are still numerous defendants that have not gone to trial yet. In this 88-page, over 55-count indictment with 26 defendants, not all of the defendants went to trial in the first trial, though the judge did indicate at a setting conference that she wondered if the prosecution would maybe regroup a little bit and be offering plea deals to the defendants that have not gone to trial yet. And we will see if that happens after those not guilty verdicts, but they were resounding not guilty verdicts. The thing that's notable about the verdicts, though, is that the jury did take their time. They started deliberating before Thanksgiving. And when they came back, they didn't just acquit on everything. It seems that this jury went through the evidence and looked at the evidence and said, yes, there's evidence that Stillwell had a prior felony and had a gun. But on all the other stuff, I don't see this as being beyond a reasonable doubt. So it indicates to me that even though we know this jury's frustrated based on questions they had asked the court, we know this jury's been there for 2 years, they still took their time and were incredibly thoughtful instead of just throwing up two middle fingers going, you know what, not guilty for everybody, let's go. It shows that they still took their time to evaluate the evidence, which is the job that they were given to do. And when they evaluated all of the state's evidence, they came back with, yeah, that's not going to do it for us. So do the defendants who plead guilty now reevaluate their own decisions? Maybe, maybe not, because you can't change it. You can't go back in time. And that's where the case remains. What the prosecution team does from here will be very interesting. And I'll keep you updated with that in the Quick Bits on Mondays. Let's talk about Kari Morrissey, shall we? Let's try to summarize her fuckery. Kari Morrissey can't let it go. It's time to sing some Idina Menzel or Adele Dazeem. If anyone doesn't get that reference, I think we should probably in post just clip it in here. But it's time to let it go. It's time to let it go. Judge Summer dismissed Alec Baldwin's case with prejudice based on the behavior of the prosecution. With regard to the Troy Teskey rounds, as it all came out in that evidentiary hearing the third day of Baldwin's trial. And since then, Kari Morrissey had said, but wait, Your Honor, will you please rethink it? And the court said no. And then she goes, but Your Honor, will you please reconsider your denial of the reconsideration? And the court said no. And she said, okay, I'll ask the Court of Appeals if they will do it. And even though she has only filed the notice that she is going to file an appeal, I don't know what lawful law she is going to appeal this on when it was dismissed with prejudice. I'm very interested to see what case law or statute would even allow the Court of Appeals to say, yes, the court here abused their discretion. Because the court found a Brady violation and the dismissal was a remedy for the Brady violation. That's going to be an abuse of discretion standard. And I don't think Judge Summer abused her discretion. And Judge Summer listed out the prior Brady violations in this case. This was not the first one. There were multiple Brady violations that the court found in this case. And the court said that she found that the prosecution misrepresented the state of the evidence to the court and to the jury. The Court of Appeals isn't going to be thrilled with this. We'll see if within the next month or so that an actual appellate memorandum is filed, and I'll be keeping an eye on that because I want to know what her arguments are. I want to know what law she's basing it on. But I don't think this is going to be successful. I think this is just going to cost more money for Alec Baldwin. And that should never be the goal of the prosecutor. That's what civil law is for. Civil law is all people being like, even if I don't win, I'm still going to cost you a bunch of money. CEG, all my coverage of the Real Housewife civil lawsuits. But that's not what criminal prosecutions are for. And when the prosecution fucks up, this is one of the remedies. And in this case, the prosecution fucked up. So no, they should not be able to prosecute Alec Baldwin again. Does that change the things that happened on that set? It absolutely doesn't. But what you can't undo is the prosecution's action in this case. No amount of appeals and continued litigation is going to change what Judge Summer did. And I will be very surprised if anything comes of this, other than Alec Baldwin's lawyers asking for sanctions again and throwing all of the shade in the world into their legal writings, which is kind of delightful. So, you know, maybe we'll get some more of that from Alex Spiro. We'll see. All right. Let's continue on. Patty in the chat said, can Kari end up in jail? No, she can't. Elisa said, did you see Wicked in theaters? Yes. I talk about it in tomorrow's podcast. Well, briefly. Yes, I did. G Mommy said, how is Kari not sanctioned? I was actually kind of disappointed that Judge Summer didn't award costs to Baldwin's attorneys. Not a sanction per se, but like, hey, you filed this dumb thing. Pay the other side for having to deal with this dumb thing. I don't know if we'll see it. Maybe we will. Maybe we won't. Eileen said, I think Andrea Burkhart has said there is legal precedent for her appeal. If Andrea Burkhart said that, it is 100% accurate. Listen to her. Her knowledge of appellate law is 10 out of 10. She is incredibly smart, and she does just a tremendous amount of legal research. So if she said there is legal precedent for the appeal, I trust her legal research 100% more than me saying, is Kari Morrissey going to cite the grounds? What I will say is, will Kari Morrissey cite that legal precedent that Andrea Burkhart has found? Because I wonder. Because in her last one, she cited none of the law. Like none of the law. None. And I sit here and wait for Kari to tell me what the law is. What is the law? What is the standard? And Kari does not do that well. Let's see. Zuna said, has a Brady violation ever been overturned, overruled? I have no idea. I'm sure it probably has at some point, but it's going to depend on the law of the area, but I don't know. Anything is possible, but off the top of my head, I can't think of one where I'm just like, what? So I think, Kari's kind of lost in the sauce at this point. So, Andrea Burkhart said there's a timeliness issue with Kari's appeal. I don't know. I have not watched any coverage about that, but if she did, that might be. Let's see. Andrea Burkhart is one of the most articulate people I've ever heard, and I'm a dark academic. She is, and she does a lot of appellate work, so it does not surprise me at all. She's incredibly thoughtful. So, yes. Yes, absolutely. My brain was trying to go like, where are we going next? And then I just buffered because I was, again, Emily, were you up late recording the podcast? Yes. Does the ADHD work well on little sleep? No, terribly. But sometimes we just have to get it done. All right. Are we ready to talk about Kouri Richins? Because let's just continue on. I'm so frustrated that this is still going, but I'm so frustrated that there were Brady violations in the first place. Like I hate everything about this. I just hate everything about this. I just stop it. Like, why are we doing all of this? It's too much. And it, I don't know. The thing is, if the court had done something wrong, I would be sitting here going, keep going, get it, let's go. But that's not where we're at. I spent the entire day, that third day of trial, going, well, the defense is going to throw anything up against the wall because they made some critical miscalculations and now they're on the back foot. And then as we got to midday, I was like, wait, what the fuck? Like, I feel like me and Erlinda Johnson spent that day going, wait, what? Wait, what? Wait, what? Wait, what? Wait, what? And then I was absolutely shocked. Absolutely shocked. This is why we need cameras in the courtroom. Because if the media had just reported this, there's no way we would have gotten the full impact of what happened, especially when the media reporting in the courtroom is not legal or not lawyers, because the things that they're going to see for the headline are different. And that's no shade. It's just different. Their focus is on different details. And those aren't the details that lawyers are necessarily focused on. Seeing it happen in real time was wild. And I think it was the only way to really, for me, distill and summarize and understand what happened. Seeing the judge pull out the rounds in gloves, going, aren't these the same? Was wild. Seeing Kari Morrissey take the stand was wild. And this is why cameras should always be in the courtroom. Okay. I'm done. Soapbox down. Emily, stop. Let's go talk about this new order in the Kouri Richins case, and then we will get to talking about some other stuff going on in the Kouri Richins case. I was hoping to have court documents. We might have to do those documents on Thursday. That's okay if we do them on Thursday, if we get them, but they're not publicly available. So we will see. It's still very early in court, and today is like literally the worst day to ask a court for anything. The Tuesday after a long holiday, and this is the only 2-day holiday in the court calendar for most jurisdictions ever, is Thanksgiving and the Friday after Thanksgiving, because even at Christmas, courts are off Christmas Day and New Year's Day, but at Thanksgiving, most courts are closed Thursday and Friday, which makes the Tuesday after, Monday and Tuesday after, kind of a mess. Let's take a swoop and talk about Kouri Richins, because this case. Oh, Kouri Richins. You might recognize the Kouri Richins case as the woman who wrote a children's book about grief and then got arrested during her book tour and was accused of murdering her husband by lacing his Moscow Mule drink with fentanyl. But wait, there's so much more. She was also having an affair with her paramour, and what came out during court hearings and her preliminary hearing is that she was telling her paramour that they would be together soon. Just wait for Friday. Yes, that the early morning hours of Friday is when paramedics came to the house and found her husband dead from a 5 times a lethal dose of fentanyl in his system. But wait, there's more. Prosecutors have also charged an attempted murder from about 2 weeks before the victim's death on Valentine's Day, when they accused Kouri Richins of lacing a breakfast sandwich with fentanyl for her husband and then leaving to go be at her boyfriend's house on Valentine's Day. And when her husband texted her saying that he wasn't feeling well, she told him just to go ahead and take a nap and sleep it off. He's like, I might need to go to the hospital. She's like, just why don't you lay down and sleep? So we have seen quite a lot from this case between the extended bail hearing the first time and the most recent hearings. This case has been pared down some. The defense team has had some pretty good rulings, and the prosecution removed some of the charges in this case that were just not a right fit. So when this goes to trial, it's going to go to trial on the murder charge, the attempted murder charge, and then some of the forgery charges in connection to life insurance policies. But the charges of mortgage fraud and forgery related to the mortgage fraud are going to be in a separate proceeding. And if she's convicted of murder, then it's likely that those will just get pled out to, run concurrent. So the court did a ton of rulings. This court has been incredibly unfriendly to the media, which is shocking to me because he is one of the most media-friendly judges I have ever seen. He is thoughtful. He is considered. His rulings are well thought out, but he is very protective of his courtroom and does not love a media circus. So he has been very cautious about how court proceedings happen, which means coverage of this case with video from court has been incredibly difficult. The court has put out multiple orders about their access to call in and listen in, which is not easy to obtain access to. And the court in everything is like, this cannot be recorded, this cannot be distributed, this cannot be that, and the other thing. And any distribution of that is contemptuous behavior. And the court has also not allowed streaming. So the media companies have put out very little clips of those court proceedings and made it very difficult to cover. So with all of that, we went through a full day of hearings with some snippets that we had in video and then filling in from me attending the court proceedings remotely. And the court made a ton of rulings about things like severing out some of the counts. The court was asked to seat a 12-person jury, which they do not do in Utah on anything that is not a capital murder case. So they are impaneling an 8-person jury. And things like in-person voir dire. The fact that the attorneys had to ask for in-person voir dire was wild to me. Because how do you do voir dire and pick a jury when everybody's on a fucking Zoom call? It's so strange. It's just so odd to my brain. But that's what they have been doing in Summit County. And that's what they have been doing. And so the attorneys fought like hell in court, both of them. The defense and the prosecution were like, Your Honor, please let us pick a jury in person. Please have the jurors come to the courthouse and sit in the gallery as a veneer, and then we can see who's coming up next. We can put them in the jury people box. We can ask them the questions. We can see if the cameras are going to be off-putting to them. We are picking a jury in a high-profile case. Please let them come to court. And the court said that he, quote, had double-checked with the mothership that that would be possible, and that he has the discretion to do so. And the court was really disinclined to acquiesce to that request, and then took a break and came back and said, you know what? I'm going to allow it. I'm going to allow for an in-person voir dire. Excuse me. And then the site judge went ahead and overruled it. So we're going to get to the site judge's ruling right now. Give me 1 second to pull that up, and no, it was up. It was the right one. Yay. Some days it happens. All right. This was filed by the site judge on November 26th. And the site judge was like, yeah, we're not doing that. We're not going to go ahead and do that. Wild, right? Wild. Pursuant to the 3rd District Court Standing Order dated September 26, all jury selections are to be conducted virtually unless a party demonstrates that extraordinary circumstances, and the judge did say that, extraordinary circumstances exist for a particular case such that in-person jury selection is necessary. And this judge found extraordinary circumstances. The requirement that a party show extraordinary circumstances is a demanding standard, although not defined in the standing order. If it's not defined in the standing order, let it go. To the judges, hey, you have to do this thing. We're not going to define it, but you need to do it. Okay, thanks. Although not defined in the standing order, extraordinary circumstances is generally understood to mean a highly unusual set of facts that are not commonly associated with a particular thing or event. The amount of media in this case is an unusual set of facts. The judge goes on to say, consequently, the extraordinary circumstance exception to the standing order should be used sparingly reserving it for the most unusual circumstances that would result in a manifest injustice. And that's what the defense said. The defense said picking a jury that cannot be fair in light of media scrutiny is something that could cause a manifest injustice to the defense. The court goes on to say, nothing here, including defendant's memorandum in support of the motion for in-person voir dire and jury selection, demonstrates that this is an extraordinary case or that manifest injustice would result from virtual jury selection. While there is no question this is a high-profile case being covered by traditional and quote-unquote new media, you can hear the derision. They're like, new media. There are many such cases in third district court. Moreover, as has been done in several other cases, issues regarding cameras and the number of people in and around the courtroom during trial can be addressed with carefully crafted jury questionnaires, jury instructions, and decorum orders. But I understand the defense's point here, saying you can say you're fine with it, but it's a whole different thing to see it IRL. The parties also fail to adequately explain why in-person jury selection is needed to address general concerns about the extreme media attention, or why the use of a supplemental or case-specific questionnaire coupled with the meticulous questioning during voir dire would be insufficient for identifying those jurors who may be uncomfortable with media attention or large crowds. They said that in their oral argument. We watched their oral argument. Nor have the parties adequately explained how they intend to, quote, expose the prospective jurors to the media and large crowds without compromising privacy of prospective jurors or the safe environment needed to answer personal questions truthfully and free from any pressure to conform to perceived judicial or community standards. Indeed, the article cited by defendant in the motion emphasizes that fostering transparency and openness during jury selection enables jurors to express their opinions freely and acknowledge that remote voir dire sessions may enhance accessibility and allow for a broader jury pool, thus enriching the diversity of jurors and aiding in mitigating public exposure, especially in high-profile cases where media attention can influence jurors. Footnote 1. From a law review article, it seems. Jury selection in high-profile cases and in-depth analysis. Finally, the parties have apparently, quote, stipulated. The judge is salty as fuck. Finally, the parties have apparently stipulated to expanding the jury veneer to include equal numbers of randomly selected jurors from Summit County and Salt Lake County. Without commenting on whether this is permissible under Utah law, I am not persuaded that any minimal benefit from exposing potential jurors to the palpable changes in energy in the courtroom outweighs the significant and unwarranted burden on dozens of prospective jurors from Salt Lake County would otherwise be forced to travel to Summit County for in-person jury selection. Because extraordinary circumstances have not been shown, the party's request for in-person jury selection is denied. Dated the 26th day of November 2024. The site judge took this upon herself sua sponte to say no. What? The judge in this case ruled that it was going to be permissible. And the site judge came in and was like, no, you're not doing that. So this is the site judge for the 3rd Judicial District who said, I don't care that the presiding judge ruled. I'm not doing it. Absolutely wild to me that without anyone asking, the site judge has now inserted herself and created an issue. I don't know why this is such a big deal in Summit County. Maybe someone can explain to me why Summit County is like, this is going to be on fucking Zoom and there's not a goddamn thing anybody can do about it. We are having Zoom voir dire. That is what we are doing. That is what the standing order says, which was probably written by this judge. And no one is flouting the standing order. Why are we fighting over this? Why is the presiding judge putting the hammer down on in-person voir dire when the trial judge said that it should be granted? You know what's going to happen? This is going to cause an interlocutory appeal. This is going to cause the defense to file an appeal and say, we cannot start the trial until the Court of Appeals determines this issue. That's what's going to happen. So this is like the boss judge. For all of you, like, what is a site judge? Sometimes called a presiding judge. And actually, sometimes the terminology, I'm using it interchangeably, but sometimes the terminology can be a little different. There are bosses at all different levels. So this is actually the PJ, not the site judge. I've used them interchangeably. Let's be more accurate, Emily. The site judge would be the judge in charge of that particular courthouse, that particular site. So the judge that is the boss, that has to do all the administrative shit that nobody wants to do, has to do the assignments, has to deal with the matrix, has to assign out jury trials, is the administrative judge, but also has to run their own courtroom. You know what the benefit of being a site judge is? You get more work and no more pay, and then everybody's mad at you, and you have to do a bunch of administrative shit. Lawyers love administrative tasks. The PJ, or the presiding judge, is in charge of the entire area, in this case, the entire 3rd district. So the presiding judge is like the bossy boss of all the judges. So it would be judges, site judge per courthouse, and then PJ over the entire county or district. And the PJ makes a lot of these rules. When I say matrix, a lot of courthouses have a matrix that they use to assign trials out to keep it balanced between all the courtrooms. So the PJ has now intervened directly into this case and said no. Why? Like, what? Why are you directly intervening with this? This is going to cause an appeal. The defense is going to say, we cannot proceed with this case until this issue is ruled on. And this judge, on their own motion, came in and said no, after the trial judge said yes. I'm going to see if I have the trial judge's ruling real quick, because I think that would actually be helpful. Let me see if I have it real quick. I think I do, but let's just double check and see, because I think it might be helpful. Chat, let me know. Do you think it would be helpful to go over what the trial judge said about this motion? We saw it on stream. So you can go to the Kouri Richins playlist. It's the last hearing that we covered. We saw that on stream, but it might be helpful to take a look at what he ordered. Let's see. And that might be helpful. You guys are like, yeah, that would help. And yeah, this is going to create, Princess Scone in the chat said power struggle much. Oh yes, this is going to create problems. And I really like the trial judge in this case quite a lot. There's no way he's happy with this. He would never, ever, ever say out loud. But to have the presiding judge be like, yeah, I know you said yes, but I'm saying no. Ooh, after it seems that he ran a lot of this stuff up the flagpole, damn, it's going to cause problems. Like problems. So, let's see. Give me 1 second. I feel like a full streamer today, like with the whole streamer is dynamic situation. Let's see where this judge's order is. Because I might only have his summary order. Let's see. Let's go through the motions hearing, and then I will pull up his full hearing and we'll go from there. But let's go to the motions hearing summary order first and then pull up the rest of it. I think that'll be helpful because then I'll need to go to the docket and grab the rest of it. This is from November 12th. This is the summary minute order of the hearing of everything that they did. These are the charges: the aggravated murder, the attempted murder, the mortgage fraud, the fraudulent insurance claim, and the forgeries. So the insurance claims are staying. One of the forgeries is staying, and the two mortgage frauds are out. They're going to be tried separately, if at all. Let's see. All the appearances of counsel. Let's get to the ruling at the end. This is a whole summary minute order. Let's see. We'll just go through it. All the parties appear. The issues before the court are defendant's motion to sever counts in docket entry 677. The court denies the motion to sever counts 1 and 2, and the rules that counts 4, 6, 9, and 10 do not reach the statutory factors for joinder, and they are severed. Counsel for the defendant argues the motion to seat 12 jurors. The motion is denied. The court grants the stipulation to expand the jury veneer. The court will need some time, some proposed numbers. Counsel for the defense argues the motion for in-person voir dire. Counsel for the defendant addresses the court. Counsel for the defendant continues with argument of on the motion for in-person voir dire and jury selection. Counsel for the state addresses the court regarding the stipulation of the parties for in-person voir dire and jury selection. The court will be in recess, and then counsel do not have further argument on that, and the court grants the motion for in-person voir dire. So this was one of the longest parts of that hearing, and the court really took it under consideration and took a break. So then we've got the pretrial conference scheduled. It's going to be December 12th. It is court proceedings. Again, they've got their rule that court proceedings, including electronic proceedings, may not be recorded. So we will see if any of that will be available. Let me go and grab the full ruling. It's just going to take me real quick. KLV, we are working on a calendar for the docket, though it's flexible. Live times are always 11 a.m. Tuesday, Thursday. In the new year, it'll be Tuesday, Wednesday, Thursday. But yes, and that is written on the channel as well. And then if I do court on non-Tuesday, Thursday days, those get sent out in notifications. What time of year is this happening again? The trial is set for May. Riley said, will the trial be streamed? Unlikely. It's unlikely it will be streamed. The court has allowed sometimes a delayed stream, like of an hour or two, and that might help, but sometimes it might be a day behind to get all of the video and then play it the next day. So we will see. But let me pull this up real quick. I'm going to have to grab it from the court document or the court docket. So it's going to take me just a moment because I didn't pull his whole ruling because we went over it. But then when I read the PJ's ruling, I was like, oh dear, that's not great. So let's make sure that we have all of it because I want to see what the judge said in his order. And I think you guys too. All right, grab that. Are we doing all of the research things together? We sure are. Let's see. And then she is a little bit hard. Her cases are hard to pull up in the systems because of the way they have her name. Utah is not easy to grab court documents from. Of all of the jurisdictions, some are much easier. Some are much more difficult. This is one of the more difficult jurisdictions to pull documents from. So give me a moment as we continue to pull that. The website is now buffering. Witness said, thanks, EDB. Listening helps me do stuff IRL, like working and stuff. That's perfect. I'm here to body double with you. But we're going to see a appeal on this, I think. So no, where is... That is not the right docket. Why is that giving me the wrong docket? Give me 1 second. Oh, court. Also, I hate doing these CAPTCHAs. It's redonkulous. Why is this not pulling the full docket? Let's see if it will do it this time. Maybe we need to use the other browser. Oh, there we go. It populated correct this time. Yay! God, court websites are spicy. All right. At least it's buffering this time. Again. Let's see. AV said first live, how many screens are you looking at? I have 3 screens that I use, which is why you will see me looking over here to one, and then I have one that's back that way. So we have multiple. We have multiple screens and are needed. I wonder if they already filed a notice. Let's see. We're going to zoom to the end of the docket and see if the defense already filed a notice of appeal, because I'm sure we'll get it. Nope, not yet. All right, presiding judge's denial of request for in-person voir dire. We just did that. Let's do where's the order for in-person voir dire? That's what I want. Give me the documents. Give them to me now. I want it now. I want it now. All right. Let's just throw this onto the desktop and pull it up. All right, y'all. Let's. Why? Why is everything being spicy? Is Mercury in retrograde? Because it's giving none of the technology wants to work today. That's okay. My brain is in the same place. All right, now we're working. Thank you. Let's pull this up. All right. Let's see what not the presiding judge. Let's see what the trial judge had to say about this before the PJ inserted herself, because Lord. So this is right after the hearing. The hearing was in November. It's on the playlist. Before the court is defendant's motion for in-person voir dire and jury selection, to which the state stipulates in part. Right. The defense agrees. The state agrees. And do you know what the judge said in the hearing before the judge ruled on this? The judge said, how long will you need to appeal if I deny this? So the trial judge was already considering that this was the type of motion that if it was denied, the defense would want to appeal. So I think that's going to happen. Under the standing order from September 26, 2023, issued by the presiding judge. Right. The standing order was issued by the presiding judge. And he said, no, I found extraordinary circumstances. And the presiding judge said, the fuck you did. Just CEG Jason Bateman. The fuck you did. The presiding judge is like, that's not what's happening. Under the standing order issued by the presiding judge of the 3rd District, quote, absent extraordinary circumstances and prior approval from the presiding judge, all jury selections in the 3rd District Court will be conducted virtually. And the judge said he had reached out and asked. But I don't know if he had prior approval. Defendant asserts virtual jury selection is unconstitutional. The state does not stipulate to this portion of defendant's motion. Defendant also asserts extraordinary circumstances justifying in-person jury selection are present in this case. The state does stipulate to this portion of the defendant's motion. The court addresses each argument in turn. The defendant has not shown that virtual jury selection is unconstitutional. Defendant does not cite any controlling or persuasive authority for the proposition that virtual jury selection, as opposed to insufficiently lengthy and rigorous jury selection, violates the 6th Amendment as applied to the states through the 14th Amendment, or any other state or federal constitutional provision. And the court's independent research does not reveal any such authority. The court's like, there's no law for this. There's no lawful law for this. It's not unconstitutional. It's inconvenient. But the extreme media attention focused on this matter is an extraordinary circumstance justifying in-person jury selection. Hearings in this matter are constantly covered by a pool videographer, i.e., a TV camera is in the courtroom. Yes, Your Honor. A pool photographer, typically the AP, yes, multiple print and radio journalists, and multiple TV producers. This coverage constantly yields coverage in local, national, and international print, television, and online media, including the New York Times, the New York Post, the BBC, multiple cover stories in People magazine, and multiple episodes of the nationally televised program 48 Hours and Dateline. Beyond legacy media, this matter is constantly covered by quote-unquote new media, such as multiple YouTube channels with between 800,000 and 1.5 million subscribers each. Is that us? Are we the 800,000 YouTube channel? Chat. I think that's us. Chat. Is it us? Chat, did we make it? Is it us? Shit, does he know we call him Judge Daddy? Damn it. Are we the drama? Is it us, guys? Is it us? I think we made it. I think that's us. I think that's us. The 1.5 million might be Court TV, but I think the 800,000 subscribers is us. I think that's us, Chad. I don't know. Your Honor, I think we're at 802,000 subscribers. It's official. He knows. It's so frustrating because we love him. And the judges that we love, look, we love some of these judges. Like, we do. But we are so well behaved. We follow all the rules. Even when we don't agree, we adhere to all of the media orders. We do not stream things that we are not allowed to stream. We are not the drama. We just cover the case. Anyway, this matter is constantly covered by new media outlets, such as multiple YouTube channels with between 800,000 and 1.5 million subscribers each. I mean, there are lots of other channels covering it, but hey, these new media outlets constantly stream audio and video feeds. Well, no, we don't stream it because you don't let us stream it. So we don't. Feeds from the pool coverage of this matter, usually the same day with as little as a 1 hour delay. You've told us a 1 hour delay is all we can do, and the pool camera stopped doing a 1 hour delay. So we don't even have that anymore. We're literally scraping. Moreover, on days on which the court holds hearings in this matter, the courthouse appears and feels overrun because you won't stream it. People would rather stay home. People would love to sit in their comfy chairs with their snacky snacks and just stream it, but you won't let it be streamed. So it exacerbates the problem. It would be easier if you allowed it to stream. Less people would need to be there in person because we don't even get the entirety of the feeds at this point. So if you're not there in person, you miss shit. Oftentimes the parking lot is full. He is so mad about the parking lot. The parking lot is full, the lobby is full, the gallery is full. This is the same courthouse that dealt with Gwyneth Paltrow. They figured it out. And the media adhered to the orders in the Paltrow case. You said, just show the person that's talking. They did. Your Honor, the court's media order from the Paltrow case dealt with so many of these issues. If they can handle Gwyneth coming in and out of the courtroom every day, y'all can handle Kouri. And the jail transports her. She doesn't even have to walk through the parking lot. She comes in through the side door from lockup. And our chat doesn't go real world. Nobody wants to know who the jurors are. We just want to see the evidence in this case. Mhm. The cumulative effect of these circumstances, the cameras in the courtroom, and the sheer volume and varied types of media attention, and the sheer number of people in and around the courthouse palpably changes the energy in the courtroom. I agree with the judge. And evaluating how jurors will react to this cumulative effect, specifically evaluating whether a potential juror can tune out the cumulative effect of the attention and impartially consider the evidence, cannot be adequately addressed through virtual means. I agree with the court here. Give the jurors every opportunity to know what it's going to be like. When they're at home on their couch holding up their cell phone to do a Zoom call, it's not the same. It's just not. I agree with the judge here. You can say, yeah, it won't affect me, but seeing it is different. I can say, yeah, crowds are fine, but the crowd outside of the Diddy court for the arraignment was fucking crazy. Oh, I'm going to sneeze. And you can't really appreciate what it's like if you're not there. I mean, we've heard Robin Runkle talk about what it was like being at the courthouse for Depp Heard. We can see it from here, but we don't have the same visceral response to it as those that are there in person, right? I agree with the judge on this. Really do. This is so because a potential juror's reaction to the level of attention garnered by this matter cannot be measured without actually exposing the potential juror to it. And while virtual jury selection effectively replicates almost all features of in-person selection, it cannot effectively replicate the visceral reaction that comes from the uncommon set of circumstances that are constantly present in this case. Things like being watched by a capacity crowd in the court gallery, being in the courtroom when the proceedings are being filmed, and being part of proceedings that are constantly covered, often in real time. If you allowed us to do it in real time, we would, on multiple print, television, and online outlets. And while the occasional occurrence of one of these circumstances would not qualify as extraordinary, the constant presence of all of these circumstances in this case is extraordinary. For these reasons, the court finds that the extreme, and I say that because that's how the judge says it, the extreme media attention focused on this case constitutes an extraordinary circumstance that weighs in favor of in-person selection. This matter is referred to the PJ of the 3rd Judicial District for approval or rejection of the motion. Okay, so the court ruled and then sought approval, and then it was denied. So this wasn't sua sponte. I should have done this one first. So it wasn't sua sponte. It was because it needed to be approved. Well, you know, best laid plans. So the site judge denied it. I imagine that's going to get appealed. But when it comes to Kouri Richins, they are going to be fighting over jury selection. And let me know what you think in the chat. I don't disagree. There are lots of things that we think we'll be fine with. And then when confronted IRL with that circumstance, you're like, oh, it feels different. And you can plan, and some of you can visualize in your head what it's going to be like. Some of us can't. But unless you've been in that circumstance, and most of these jurors have probably never been in a courtroom before, and definitely have not been in a courtroom, like it would be the very unusual circumstance that any of them have been in a courtroom with this level of media attention, you don't know what it feels like. Being in a courthouse with a high amount of media there is a different energy. It is a different vibe, and it feels sometimes a little anxiety producing. It's not always exciting. It can be a little anxious-y. Going to work on the days that Lindsay Lohan was in court at the courthouse I worked in was a lot. And it was a crush of media in front of the courthouse. This case isn't going to be like that, but it will be some. And it's going to feel like a lot, especially in a smaller courthouse. You don't need as many to make it feel overwhelming. So I think this will get appealed. And it's a lot. So we'll see what happens. But I don't love the presiding judge being like, no, we're not doing that. Let it be. Let it be. I don't love the virtual jury selection. I understand in more remote counties that it might be the thing that is necessary to assure that you can get a jury, but I also understand in this circumstance why this is not the best way to proceed. So I empathize with the defense and the prosecution in this case. Both the attorneys are asking for it. It's always so strange to me when both sides are like, can we do this? And the court's like, no, you can't. It's like, but why not limit the amount of problems? Just limit the problems. This is a problem that can be limited. Jury selection is one of those things. When stuff goes wrong with the jury, Court of Appeals don't like it. So we'll see. We have more to talk about with Kouri Richins. Let me double check and see. Nope. All right. Well, hopefully we'll have documents before Thursday, and we'll cover with documents when we can. But we're still going to go to the park record and talk about recently unsealed search warrants, which some of the media have. I do not yet have. That's not the right one. Having to switch screens between all of the different things we are doing is much. All right, here we go. Let's talk about Kouri Richins. More. New evidence emerges in Kouri Richins' case. Search warrants suggest that the Camus, the walk the dog defendant, allegedly asked a second employee to procure her fentanyl. So she was asking for fentanyl from more than one person, they are reporting, which is a very interesting circumstance indeed. Let's see. Herbert, no, my dyslexic brain is going to put an R in the wrong place in that. HC police have agreed to hand over a cell phone belonging to a former employee of Kouri Richins who was allegedly asked to procure drugs for her in the weeks leading up to Eric's death. I can't find reading mode on my browser at the moment. The witness, William Hayden Jeffs, worked as a handyman on several properties Kouri owned through her real estate business, according to a search warrant signed on November 6th. Summit County Sheriff's Office detectives said that they interviewed Jeffs earlier this year, and he showed text messages allegedly corroborating the statement that Kouri asked him to supply her with fentanyl and propofol. Jeffs provided copies of the text to investigators, the search warrant said. Oh boy. Oh boy. He is the second employee of the Camus mother of three accused of asking, He is the second employee that the Camus mother of three is accused of asking for drugs before her husband's fatal overdose. The word accused there is weird to me. If she asked him, she asked him. It goes on to say Eric died after consuming 5 times the lethal dose of fentanyl, according to autopsy records. Well, yes. Summit County prosecutors accused Kouri of poisoning her husband with a laced Moscow Mule and arrested her in May 2023. They allege Kouri purchased illicit fentanyl from an acquaintance who is a housekeeper she employed multiple times in early 2022. And they have all the messages to back that up, and that person is going to be testifying. That person also got a deal for testifying, but they will be testifying. Phone records show that Kouri contacted the housekeeper several times in January. However, the content of the messages is unknown because they were deleted. There were some Facebook messages that were recovered, though. The housekeeper told detectives Kouri called or texted her asking for fentanyl, so she asked an acquaintance to introduce her to someone who could sell her drugs. The acquaintance gave the housekeeper a name and phone number, and a meeting was arranged. Court records state the housekeeper met the individual at a gas station in Draper on February 11th, 2022, and purchased between 15 and 30 pills believed to be fentanyl. So with this witness has other drug charges and got a plea deal because of her testimony and cooperation in this case. For prosecutors, I can understand why they would want to have both people if Kouri was asking around, because even if the jury is like, I don't know about this person, I don't know about this informant, I have questions. Having two individuals saying the same thing and then having text messages on the other individual's phone makes it a lot easier to show whether or not this is what Kouri was doing. Either way, she got fentanyl. 3 days later, on February 14th, the defendant prepared a sandwich for Alec Richins and placed it on the seat of his truck with a love note. Shortly after consuming the sandwich, Alec broke out into hives and had difficulty breathing, the search warrant said. That's new information. We didn't know it was in the truck, because when they talked about it at the preliminary hearing, they said it was on the counter and that she left to go to her paramour's house. Alec administered his son's EpiPen to himself and fell asleep. Prosecutors say he believed he had been poisoned and told a friend he thought he almost died. Kouri allegedly asked the housekeeper to procure something stronger in late February. Alec died less than a week later. The search warrant signed earlier this month does not indicate when Kouri may have contacted her handyman for fentanyl. Jeff's 35 died in a motorcycle accident on September 30th. And that is going to be a problem. His cell phone was seized by the police department in a separate investigation. Officers released it to the Summit County Attorney's Office after the warrant was served to assist with the homicide case. A second search warrant was also signed November 6, granting law enforcement access to the Richins' home. Investigators wanted to collect any and all documents, writings, and journals located on the Richins family home property, including outbuildings, garages, and detached homes. Well, yeah, because she was writing like Dear Diary. That wasn't strong enough fentanyl. The prosecution said in their oral arguments that Kouri was writing in her Dear Diary, like girl boss manifestation, like live the life you want journal, that she learned that she needed something stronger, which is a problem. So they're looking for more writings and have reason and probable cause to believe that there are more there. Kouri is charged with 9 crimes, including 2 first-degree felonies, aggravated murder and attempted homicide, murder and attempted murder, as well as second and third-degree felony charges for mortgage fraud, making a false insurance claim, and forgery. Judge M on November 12th granted a request for prosecutors to drop the 2 second-degree felony charges on distribution of a controlled substance. Yeah, because they were dumb. Kouri has been held in the Summit County Jail since her arrest, and then her motion to be released was denied. Kouri Richins and her family have maintained her innocence. Quote, with 2 charges dismissed and 4 others severed, the defense stands more confident. Really? The case against our client is rapidly narrowing, exposing deeper weaknesses with each step. That's a bold statement. The case is narrowing because they took the mortgage fraud out and they'll try it separately. But the murder and the attempted murder and her text messages and her journal entry notes and her saying she needed something stronger is I don't think it's exposing deeper weaknesses in the case. Her Google searches are pretty wild. So we'll see how that works. But I appreciate that the defense is like, well, we think it's getting stronger. It might actually be to the prosecution's benefit to not get caught in the weeds on the mortgage fraud. There was so much financial information that was brought in. And I know a lot of you felt in the Murdaugh case when they got into the weeds on the financial stuff. It's like, are we in a murder case? We in a fraud case? Like where did the murder case go? And the danger of that happening in this case, though, I think the prosecution was more succinct about it, but there is deeply technical information in the mortgage fraud part that's just not going to come in now. So we'll see what happens, but it's going to be interesting. So we will go over the fine details of those search warrants once I have them. Probably on Thursday. We'll see what else happens between now and Thursday. I'm sure it will be a lot. But you've got questions, I've got questions, we've got questions. Let's answer some questions. So, Kouri Richins, it seems, asked her handyman to procure her fentanyl. The thing that we learned from this newly unsealed search warrant is that not only has his phone been turned over, but also that he tragically died in a motorcycle accident in September of this year. So it's going to make it very difficult for prosecutors to bring in those text messages. It doesn't mean it will be impossible. It means it's going to be the subject of quite a lot of motions. However, they don't have that phone extracted yet. It was just turned over to them in November. So this is going to be later discovered evidence, and there will have to be motions about it. But I also think, based on the presiding judge of the 3rd District in Utah denying that motion for in-person voir dire, we might see the defense taking out an appeal now to try to appeal the ruling on the in-person voir dire. The reason I think that that's the way that it's going to go is because before Judge M ruled on this at the motions hearing in November, he asked the defense, if this is denied, how much time do you need to appeal it? Judge M knows that the defense is going to appeal any ruling that revolves around the denial of in-person voir dire. So I think the presiding judge denying that request for in-person voir dire is going to result in a defense appeal. Will there be enough time between December and May of 2025 to get that done? I don't know. There might not be. So we'll see what the judge decides to do here. We'll see if the defense appeals that ruling. But for now, there is more evidence still coming in the Kouri Richins case, even though this is a homicide that happened in 2022, an arrest from 2023, and we're damn near at the end of 2024, and this trial is set to go forward in 2025. So we'll see what happens from now, I guess. No, from here, we'll see what happens next. Lyndon, no words are so hard because I'm so tired. So yes, it's worse. The brain functions worse on less sleep. And it's been a couple days of less sleep. So that has been the case. So yes. In person. So a dolphin jury. Yes. A porpoise jury. That is what we need. Just a porpoise, a jury that is on porpoise. I'm going to get to some of your questions, and then we are going to take a break. Danger Kitty 83 said, got my questions hoodie as an early birthday present. Love it. And the goodies were awesome. I'm so glad. Lyndon said the risk is that the argument can always be made, well, it didn't solve her money problems. It may not work, but it can depend. That it's a fair point that her killing him didn't solve all of the mortgage problems and wasn't going to. So Lynn's asked, who died? The handyman who Kouri was purportedly texting about procuring fentanyl. Cleopatra said, anything new on Hannah Gutierrez's case? Not that I have seen. There should be an appeal filing at some point, but we haven't seen it, or I haven't seen it. That man said, right there with you, can't catch up on lost sleep. Yep, it is not helpful. It's just getting better sleep going forward. It's been busy, and then coming off of the holidays, it's just been busy. So, but that's okay. Tomorrow there will be a new Emily Show podcast for you. And we're going to talk about Drake and Kendrick Lamar and Tom Girardi. You know, all the things. Music to My Soul said, was it the site judge who made the ruling initially? No. The trial judge made the ruling initially, and then that presiding judge came in and was like, nah. Hazel said the PJ wants their 15 minutes of fame. The PJ wants their order to be followed more closely, apparently. Dear Judge Daddy, we are lawful law, promise. We are. We are lawful law. Could this ruling in Richins' case be an appeal issue? I think they're going to appeal it. I think they're going to appeal it before it goes to trial. But yes, I think they're going to appeal it before it goes to trial. Kari proves the self-representing lawyer is a fool. Kari's definitely doing all of the things. That's for sure. Loudmouse said Indiana jury pay as of 2023 was $30. Appearance pay, first 5 days, $80 after 6 and $90 after that. Go Indiana. Good. That's good jury pay. I mean, most people make that hopefully in a day working, but that is better jury pay than most. Jacob Smith said, EDP, I would love your opinion on my opinion on why Morrissey is doing this, when and if you are willing, govern to change. Jacob, I don't know what your opinion is, but I feel that this is a visceral response of Kari Morrissey going, you guys have to see it my way. If you see it my way, you'll understand that this was not relevant to this case. Because Kari's like, this is not relevant to this case. And I think that's why we are here. Colleen, thank you so much for the gifted memberships. Jen P said, yay, went to the mailbox, found my fax notebook. Amazing. So glad to hear it. Brandy said, if all the members access orders shipped, I still haven't gotten a shipping notice. I don't think the internet ate your order. There is a contact link on the Law Nerd Shop website, and I will ask the team after stream about that. We did just get back to work from the Thanksgiving holiday, but hit the link on the website and we will go from there. So, because I do not have an update since the holiday on shipping statuses. Alicia said, not done. She comes back to talk about reopening, please. That was in the YSL case. And yes, I'm not surprised that the judge is like, maybe the government wants to reconvene and see what they're doing. Janelle J said, happy to be a part of the Law Nerd community. Janelle, we're happy to have you. Absolutely, for sure. Just got my Shop 2.0 merch. Love it. Thanks, Team Baker. Francie Lou Who, I'm so glad. They are incredibly soft. Allie said, BF got me logo shop stuff and we have the early ordering gifts. The Pokemon cards killed me. I was screaming and hitting my boyfriend with a gavel. It was an early Christmas present from him to me. He regretted getting the gavel. It's squishy. I don't even know where mine is. Oh, it's right here. It's squishy. For people, not pets, but it is squishy. But would I love to make pet toys that look like this? Yes, someday. Yes, I would. Yes, I would love to make gavel pet toys. I think they'd be fun. Hicker said, Emily, you cracked me up yesterday watching Sarah Boone. I almost watched the Quick Bits twice. Yesterday was a wild adventure. And here's the thing about Sarah Boone. Like, there's a part of me watching yesterday that's horrified. And then there's a part of me that's like, well, we knew she was going to say some shit. So am I surprised? Nah. But I'm still surprised. But like, we knew she was going to say some shit, but I was still kind of stunned with how much shit she said. What? Here is my apology. I forgive you for all the fucked up shit everyone has done to me. I forgive you for the things you made me do to you. I forgive you for the hardship you've imparted on me. I forgive you for the scarlet letter that I now have to wear. I forgive you for me having to go through the hardest thing in my life, but also the most beautiful, because now my relationship with God is more solid than it ever was. Girl, find God before murdering people. So, the Kintu Sukurai, which I have never heard called that, but it was just such a, I forgive you for what you've done to me. And it was not a request for forgiveness. It was an forgive me. Forgive me. It was so damn wild. It was so wild. Casey Katz at EDB, can we get a members only with Amy and talk about all of her Olympic experiences at the last Olympics? That would be an amazing chat. Well, Amy and I always have amazing chats. And yes, I will talk to her. Amy and I need to be in person together soon. So we'll have to talk about whether we make that happen in person together, because that would be hilarious. Kelsey, thank you for the 5 gifted memberships. Malin said, hope you had a good day. How does it work when someone working as a prosecutor or criminal lawyer is called for jury duty? Best wishes from Sweden. It depends on the type of jury duty. So this can play out in a couple different ways. I have been a district attorney in my county, and we had one of the largest prosecutorial agencies in the world, and the largest in the United States. So there would be the very rare occasion where someone from my own office would pop up in the jury pool. That is a conflict. They cannot sit on a case by me. If we are in the same office together, we are colleagues, they cannot sit on my jury. So it was like, hey, grabbing lunch, but you can't sit on my jury. However, because the system in our states is deeply confusing, there are jurisdictions and circumstances where within Los Angeles County, you can have local prosecutors as well. So you can have a city attorney office and a district attorney's office operating in the same area. So the LA city attorney could prosecute a case that the district attorney's office is not prosecuting. So like an LA district attorney could sit on an LA city attorney criminal prosecution. The defense would probably kick off an active prosecutor in a criminal matter, but in theory, they could sit on that case because there are prosecutions at the local level, like the city level. And then there's prosecutions at the county level. And then there are also prosecutions at the state level with like the state AG's office. And then there are federal cases as well. So let's just go with LA, the city of LA. In the city of LA, in theory, you could be prosecuted by the city attorney's office, the district attorney's office, the attorney general's office, or the United States attorney's office. There are 4. Are all of you like, what? 4. So if you live in Los Angeles, or if you're in the city of Los Angeles, those are the options. There are 4. So if you are a DA, you could sit on a jury for the city attorney, the state's attorney, or the United States attorney. So those are the 3. You could sit on somebody in a different jurisdiction. Generally wouldn't happen. But there's also a bunch of civil cases. And sometimes, like the LA City Attorney's Office will prosecute civil cases. So you could also sit on a civil case. You could sit on a grand jury case that's a civil case, or a grand jury case that's not a civil case because they keep you on the grand jury case. So in theory, you could sit on those cases if you weren't removed for other reasons. It's just not something that happens a lot. I left a lawyer on one of my juries once. And at the end, the lawyer was like, I would love to see your handwriting a little bit neater. And I really don't like the color pens you chose to use in your closing and blah, 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 blah. I'm like, I didn't ask you for a critique, bro. Like, why do you want to talk to me? Is it because I'm young? Dude, I don't need your feedback, but thanks. Never again. I never left another attorney. I didn't want to hear it. I don't want to hear what you have to say. You don't do my job. You don't understand my vibe. And perfection is not what I'm going for as a prosecutor. It is explaining things in a human way. So, never again. Never again. But yes, it can happen. It's unusual. Even being retired, it's unusual. I'm curious what happens if I get called for jury duty living here. As a former criminal attorney, I imagine most defense attorneys would be like, nah, what they don't know if they don't watch my YouTube channel is that I tend to be way harsher on prosecutors, I think, than I am on defense attorneys. I think it's easier to be more critical of the job you did because you've walked in those shoes. And so you're like, come on now. It's like when you worked in retail. You worked in retail and you're like, come on now. You can do it. So we'll see. But yes, it's possible. It's just unlikely. Let's see. Laura said, this is regarding Kouri Richins, that the state has an 1102 statement from him used during the prelim. He met with prosecutors and his attorney. It was discussed in May in court. It's been a minute since they discussed it, but yeah, there are some ways that we might see this testimony from Kouri Richins' former employee or handyman coming into court, especially when they get his phone. I'll be really interested to see what the search warrant says. But yeah, there are ways it can happen. Rolling Along said, did Kari and Baldwin date once and he dumped her? She's real mad. At some point, can Baldwin have Kari held liable for paying his attorney's fees? He keeps asking. And at some point, yeah, it might happen. It very well might. Wine Yogi said, missed you live yesterday, but replay was epic. Yesterday was an adventure. Like yesterday was an adventure. Marie said, ordered 11:20, no info, no response to my emails. Marie, if those are going through the website, there should be a response to them, unless it was literally like Wednesday of last week. But those should go directly through the Lawnard shop, not to an email address. But those reach outs should go through the shop. And if that's happening, we can check on it. I highlighted it so the team has your name, and hopefully the order is under the same name, so it's easier for us to track back, because that shouldn't be happening. But we also switched our distribution, so it's something that we will absolutely look at if the team hasn't already been doing that, because we did just get back to work from the Thanksgiving break yesterday. So with that, let's see. Andrea said, please check your chat messages on the gram. Okay, I will check my chat messages on the gram. It's been a minute since I've been in my DMs on, well, anything. I think Sarah Boone is equally angry the judge didn't give her more attention. Maybe that's why he didn't. I was looking forward to it too, though. Kara, that's a great point. That is a great point. I mean, it was a baffling experience, but you do make a good point that when people really want attention, withholding attention is a very strong play. I'm going to go with that. I just wonder if it's this judge's practice. I don't know. I haven't had a chance to watch Peter's coverage. I watched along with Natalie Lawyer Chick when she was live a bit yesterday before I recorded the podcast, but I haven't had a chance to see if Peter has said anything about what his takeaway was from the judge keeping the comments to a minimum, if that's common in Florida, if that's common from this judge, if that's what he thought. I would be interested in his take on that, and I'll go seek that out later today because I'll have a little bit of time. Music to my soul. I meant, did the site judge make the rule that voir dire would be Zoom only? Yes. Not the initial ruling. Yes. Yes and yes. The decree for the Zoom voir dire is also from this site judge and requires the site judge's approval. So no, I'm gonna bop around and see everybody's coverage of yesterday. Sometimes somebody's gonna make a super cut of all of the lawyer reactions to Sarah Boone, because I think everybody's probably watched it at this point. So I'm gonna go jump around and see everybody's thoughts, because I want to see I want to see all of them. Like, what did everybody think of the pen pal? What did everybody think of Sarah Boone's statement? Like, how did that happen? Like, I want to know. I just haven't had time because yesterday was a busy day, and then a podcast needed to be recorded, and then I needed to sleep. Not enough, but I needed to sleep. So I wonder if we're going to see more filings from Sarah Boone to the court. I really wonder, especially now that she doesn't have Owens, because Owens is going to be done with this portion of the case. She's going to get an appellate lawyer. I wonder if we're going to see her still writing to the judge and being like, hey, I'm not happy with my appellate lawyer. Like, I wonder if we're going to just like circle back to it. It'll be interesting to see. All right. At Nightbot, EDB is hyping up the other channels. I did mention it. Nightbot has been mindful of, on occasion, people wanting to talk negatively about other streamers. And I realize it's hard to nuance it, because if I mention other streamers, I only talk about it in a positive way. I mean, we haven't talked about streamers that I don't know. Maybe I've talked about any of them in a negative way. I don't know. But there are times that there are back and forth about other streamers and what they're doing and how they're doing and whether people agree with their take or don't agree with their take or whatever. And we try to limit that, and we try to limit self-promotion or just aggressive promotion of what other people are doing in the stream, because it derails the conversation. So we really do try to stay on topic. But yes, Nightbot is set up for the average circumstance, not for me saying, I want to see the entire internet respond to Sarah Boone, which is helpful for Nightbot to keep us on topic and not reacting to other people's reacting, which can sometimes happen when multiple people are streaming at once and people want to watch all the streams and be like, so-and-so said that. It can be hard. And I don't want it happening to other streamers either, that like, oh, Emily's doing this or Emily's saying that. It's like, you know, when we're all streaming, it's just, you know, we could just do the thing and stay on topic here, and then we can bounce around and go watch all the things. So with that, I am going to get going. My head has very much started to hurt. So my brain is like, turn off the light. But that's because it's been a long day. And yesterday was a long day. Tomorrow, however, there will be a new podcast episode for you at 11 a.m. We're going to talk about Drake and Kendrick and all of the things. And we're going to see how far we can push UMG music licensing, which I'm going to go talk to Team Baker about right now, because I'm like, let's fucking go. Let's send it. Let's just see. And then we are counting down towards the holidays, towards some travel for me, and to 2025, when we're going to be streaming 3 days a week. So I'm ready. I think you guys are ready. And like, are you ready for it? Yes, 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 yes. Fair Green is this is going to be the last question I answer. Fair Green said, can prison allow to give a kidney? It's going to be very, very, very unlikely. And I don't know if all states would even allow it. Here's why I say it's unlikely. Having her in hospital and going through surgery at the expense of the prison system is really unlikely, especially considering it's not for a family member. I would imagine a circumstance where if it was a direct family member, a child or something like that, there may be room for an exception, but somebody that you met off the internet, no, probably not going to happen. Probably not going to happen at the prison's expense. Because then the prison has to deal with what happens if she gets an infection, what happens when she's recovering. It causes a whole world of issues. I mean, there are prisoners, because they're not allowed to bring in contacts, who can't even get prescription eyeglasses in custody, adequate dental care. Prison medical is difficult on a good day. So the transplant that is not for her would be seen as a not needed and a liability and an expense. I also don't think Sarah's going to really fight it that hard. I think she likes getting money on her books. Maybe I'm just being cynical. You let me know. You let me know. Maybe I'm just being cynical, but she's got the rest of her life to figure it out, doesn't she? All right, chat. I will see you in the chat tomorrow for the premiere. I will see you back here on Thursday. I'm sure lots will happen between then and now and then. So stay tuned on the Law Nerd app, and I will talk to you soon. Thanks for being here. Thanks for being a Law Nerd. Good to see you guys. Talk soon. Bye.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.